Well, let's go ahead and get started. Thanks to everybody who chose to stay until the very last afternoon session on the very last day of the conference to hear about this incredibly esoteric and messy subject of copyright law. We probably won't take the whole time. We have a very large portion of time blocked out, but even I can't deal with copyright for 3 hours straight. However, I don't want you to think that I want to make sure we have lots and lots of time for questions and conversation. So we have a generous amount of time for that, which is good. I'm here with Joy Ito, who is the chair of the board of Creative Commons, or is that the right title? Yeah, of Creative Commons, among many other cool things. And he's going to spend some time talking about Creative Commons and other licensing possibilities, as well as anything else that kind of comes up from the conversation. I'm going to basically go through what I think is a very nuts and bolts Copyright 101 for creators sort of framework that sets out the rights and all the basic way that it works for you in about 5 or 10 minutes. And then we'll spend some time talking about source material and how to think about going about getting source material in light of copyright law. We'll also talk about fair use. There are a lot of questions usually around fair use and the licensing issues that I mentioned before. And we'll spend some time actually talking about the Digital Millennium Copyright Act. Both the anti-circumvention provisions, which make it illegal to decrypt a DVD, for example, to get source material, and the take notice and takedown provisions, which allow YouTube to post things without filtering it in advance, so long as they respond to a notice of infringement by a copyright holder by taking the material down. And that has pros and cons, both for the intermediaries and for you folks. If you have a blog, for example, you can sometimes take advantage of the safe harbors that the intermediaries get as well. So that's the sort of basic framework, punctuated with lots of time sort of for questions and conversations. I don't want to tear through the whole thing all at once because it would be a little bit long. So feel free to break in, and I'll let you know if I'm about to get to it, or we'll just stop and talk about it. After an hour or so, we'll take a break, or an hour and a half, we'll take a break, so we're not doing copyright for 3 hours. I do have to tell you this. I am a lawyer. I'm a law professor here at the University of Southern California, and I also run the Intellectual Property and Technology Clinic at the law school, where my students represent artists and nonprofits and other folks in the public interest in intellectual property and technology law. And as a practicing lawyer, I do have to take care not to give legal advice inadvertently. It's an ethical rule that is important, and it constrains us. So what that means is if I'm being a little frustrating, I really don't intend to be, and I apologize in advance. I usually can't speak to specific questions, so I can't answer your specific question about your project because we're not in an attorney-client relationship, but hopefully we're going to be able to have enough nuts and bolts that this is useful. This is my academic opinion, USC's opinion. This is not USC's policy. I'm visiting at Stanford this year, so it's not Stanford's policy either. And now that we have that out of the way, we can get started. So when thinking about creating remix work or other work as a creator, dealing with source material, one of the big things that people think about and are anxious about, of course, is copyright. And this is all very straightforward, what I'm going to show you, but this is the approach that I think is most helpful to take. So the first question when you have some material that you want to use as source material is just ask if it's covered by copyright in the first place, because by no means everything is, and we're going to talk about that a little bit more. If it's not covered by copyright, then it's free to use for purposes of copyright law. Secondly, if it's covered by copyright, would you be using it under an exception to copyright, most commonly fair use? And we'll talk about that a little bit more. If so, then go ahead. It's free to use. Stop on the flowchart. Is it not something that's covered by an exception? Not something that would be a fair use? You're pretty sure. Well, there may be source material available under a generous Creative Commons license. There may be source material available under another kind of generous license. Then you can follow the terms of whatever that license is and go ahead, and it's free to use. Only after you get through those 3 steps would you, from a copyright law perspective, need to think about asking for permission from the copyright holder. However, you know, there are political reasons and business reasons why people may decide to ask for permission in advance. But until you go through the first 3 steps in the flowchart, there's no copyright need to do that. And here's an issue which we can talk about if you're interested later. Sometimes you try to get permission, and you look and you look and you look, and you can't find the owner at all for some reasons that we'll talk about in a minute. And in this case, you have an orphan work, and that's a real conundrum that we can talk about more if you're interested. So to answer that first important question, how do you know if something is covered by copyright? And there's a lot of opinion and a lot of information out there, some of which is accurate and some of which is not as accurate. And that's just because copyright law is really complicated and really nuanced, and the statute is this thick, and the case law that interprets the statute is even thicker. I mean, Nimmer on Copyrights, which is the treatise that a lot of copyright lawyers use, literally takes up an entire shelf in my office. So it's very understandable that it's not something that is easy to get your head around, but hopefully some of this mapping will sort of help you get a basic understanding. So in order for something to be covered by copyright in the first place, it has to be original to the creator. It has to be their original work. How much originality? Not much. It doesn't have to be incredibly original in order to be covered by copyright. So it's not as though you have to be super creative. For example, even if you take a bunch of things that are in the public domain and you sort of put them together in a creative way, there is some level of copyright protection in that, although it's thin. There's not a lot to it, but there is some level of protection to that. But don't think that originality is a very high bar to copyright protection, because it's not. The second thing is fixation in a tangible medium, and this is where we get sort of metaphysical, which is common with copyright law. If I simply extemporize, as I'm doing now, it's being captured. But if I don't have that written down anywhere, and I've never recorded it to tape, then it's not fixed in a tangible medium, and it's not covered by copyright law. Actually, practically speaking, of course, particularly now that we have so many forms of media and they're ubiquitous, it's unusual that you come across something that wasn't fixed in a tangible medium, but if it wasn't, it's not covered. And then the most important set of limitations in today's world is whether or not it's the proper subject matter for copyright law. Copyright doesn't actually cover everything. It covers a bunch of stuff, but it doesn't cover everything. So I've put out in this, the list of the items in the statute, and they're defined specifically in the statute. It's not necessarily a lay understanding of what's covered. Those are the kinds of things that you can get copyright for. There's another aspect to what proper subject matter, what is proper subject matter. It's not just the kind of item. It's whether or not, again, going back to the originality requirement, there is original expression that is being protected here. Although we all sort of know, let's say we all know the basic facts of the Civil War, all of those facts are shareable, they are free. It is my version of the story, it's how I express it in a narrative form, in a visual form, in some other form, my originality that I've added that is actually copyrightable. So the way I talk to my law students about this is I say, again, it's kind of metaphysical and abstract and a little silly in some ways, but the work, the copyrighted work, is entirely an abstract principle. You can imagine it sort of floating above the book or the movie or whatever it is. It's all of the things that are the original expression of the copyright holder, the actual way that the novelist describes the narrative, the actual order of the images and the way the camera angles work in an audiovisual work. It's not a bunch of other fundamental elements that are underlying the work. So some examples of the things that fall out and are not protected are facts, as I mentioned. Ideas, those are for patent law. Only when they are expressed originally by somebody are they copyrightable. And things that you might not expect, like short phrases and titles and slogans. A lot of people think that those are not free to use under copyright law, and that isn't true. They're actually not copyrightable. They may be covered by trademark, but they're not covered by copyright. So there's another level of complexity when you're looking at a source work and you're trying to figure out what copyrights cover it in the law, which is that not all. Whoops! I put my sorry, I put my, is that each of the different categories of copyrightable work in the statute has its own set of characteristics and its own set of rules. And this is not a very detailed slide, obviously, but it just covers some of the types of copyrighted work that will often come up when you're doing remix work. So obviously, literary texts are less relevant in an audiovisual world, but you have to remember that there may be a source text, there may be a screenplay behind that, there may be a book behind it. The level of the copyright claim against the remix from the person who was a text source may be somewhat low, but that's also something to think about. The other thing that this is, copyright law is a little wacky, is that literary works actually include computer programs. So copies of computer programs are considered literary works. One thing that is extremely important to a lot of remix work and comes up a lot is music, of course. And the only thing I want to highlight about music for the moment is that music actually involves two separate copyrights, and possibly and likely two or more separate copyright holders. So the actual musical composition, which is usually fixed in the form of something like sheet music, right? The actual music itself is covered by copyright in the form of a musical composition. The record labels have their own special copyright. They actually have a copyright granted to them in the statute in the actual recording of the music itself, in the sound recording it's called, the master tape. And it has some limitations on it because it's kind of odd to imagine that not just that metaphysical sort of a work, that abstract work, but also the sound recording could have a copyright. But they do. There are two separate recordings in any musical work. By I just mean naturally that's probably going to be in your remix work. Secondly, audiovisual works, again, naturally, that's usually in your remix work. Pictorial, graphic, and sculptural works come up because still photos, those types of things would be in the remix work. And then actually architectural, choreography actually could come up. But I won't go there. There have been some crazy complaints to take things down off of YouTube. You're doing the electric slide at weddings. But we can talk about that later if you'd like. But architectural works, I wanted to highlight this just because it's on the list, because it's in the statute, but it's also limited. So photographs of buildings that are there in the public, that is not actually what's covered by the architectural work copyright. You may again have a trademark issue, but you can take photos of public buildings and use them. That's okay under copyright law. Even though if you have looked at the source material and you have sorted out how many copyrights you think there are in the source material, there may be a lot of other legal issues to contend with. Trademark right of publicity and privacy torts are the ones that I've highlighted here, and I expect that we'll sort of weave them through the conversation a little bit as we go. Joey has some releases he's been working on to help creators around right of publicity and the privacy torts, and I'll talk about them as they come up. So what actually does the copyright holder get to control? A lot of times, this is something that's, again, it's common in the public vernacular. People sort of think about copyright, but when you actually drill down to think about what it is a copyright actually covers, that isn't something that is necessarily as intuitive as it may first seem. So copyright grants these 5 exclusive rights, digital audio transmissions, I put off to the side for a minute, basically 5 exclusive rights and no more to the copyright holder. Not all flavors of works get all 5 rights. So literary works, musical compositions, audiovisual works, choreography, and pantomime all get the right to be performed. So if somebody performs your copyrighted work and you have that kind of a copyrighted work, that's a violation of your copyright. But for the other types, performance is actually not one of the rights. So where this is the most obviously important is with sound recordings. Sound recordings, you'll see, don't have a line. They don't have any performance right. You can play a sound recording to a room full of people and you're not infringing the copyright in the sound recording because it doesn't actually involve that particular right. However, the musical composition, the underlying music, is still embodied in some sense in that sound recording, and there you may implicate the copyright. So copy, just as it sounds, reproduce. All different kinds of works get that right. That's basic. Derivative works, which we'll talk about in a minute, again, it's a little complicated. All works get that right. All copyright holders get the right to decide when to distribute their copyrighted works. And then there's this performance, which splits out among some works and not others, and then display, which also only applies to some works. And you see that this sort of makes sense, right? Display applies to pictorial and graphic works, whereas perform and display both apply to audiovisual works. Display is, putting it on the wall for people to come see. Doesn't really apply so much necessarily to other types of works, but it obviously would apply to a painting. So when you're thinking about the copyright in your source material, it's good to understand exactly which parts are roped off for the copyright holder, if that makes sense. Okay, any questions on that before we move on? As I said, this is very Copyright 101-ish, and we're just going to flip through and then get to the more interesting stuff. Yeah?
Just a quick question. The fixation that you mentioned in the very first part, the fixation, does that have to be done by the copyright holder, or could it be done by someone else?
Actually, that's a really, so the question for the recording is, does the fixation have to be done by the copyright holder, or could it be done by somebody else? And this is actually a pretty complicated legal question. So normally the copyright holder is the person who at least authorizes the fixation, but frankly it's a little bit unclear. There is the ability to have simultaneous fixation of certain kinds of works that are happening and being recorded at the same time, most notably NFL games and Major League Baseball games. They have a special rule, and this is common to copyright. There are lots of special rules. They have a special rule that as long as they follow these pretty complicated set of requirements, they're able to fix the work as it's actually being played on the field and therefore claim copyright in the source material on your television. Whereas if you were just watching a game and it wasn't being simultaneously recorded, it couldn't be copyrighted, right? Because there's no fixation going on. I mean, even if we get past the issue of whether we're talking about ideas or methods or what are we talking about here, it wouldn't be copyrighted. There is a separate statute which makes it illegal to bootleg concerts. And it says that the performer has the right to authorize the fixation. So before you get to the copyright, the performer has the right to authorize the fixation. And they're the one who has the ability to say yay or nay on that. That actually is a statute that has been challenged as unconstitutional. Because copyright law can only, it's constrained. It can only be so broad and it can only last so long because the idea behind copyright as set out in the Constitution, in the power granted to Congress to pass the laws in the first place, is that it's supposed to promote progress. And it has to be for limited times. The idea being, we think of this very economically in this country. We'd like you to create. So we'll give you some exclusive rights so you can make money from your creation, thereby getting you to create because you have an incentive. But we don't want you to be able to lock up that expression forever because, of course, everybody needs to be able to comment, to remix, to work with it, to build upon it. And we have the First Amendment to contend with. So it has to actually end over time, and there have to be these limitations on it, one of which has been the requirement that it be fixed in a tangible medium. And what courts are going to say in the end about that bootlegging statute is a little unclear. So far, the courts have said that it's constitutional. But you see, I'm sorry, everything becomes like this complex question, but really do keep asking if you're curious, and we can talk, more deeply about any piece. Okay, so but this is all pretty straightforward? Yes?
I have a quick question regarding what's covered under fair use for nonprofits.
So we'll talk about fair use and pretty much in detail later. Yeah. So, but great. Okay. So I wanted to come back just to the derivative works right and talk a little bit about what a derivative work is. This is probably the broadest right that the copyright holder has. The reproduction right covers basically copies of the work, like actually making copies of the work. Derivative works were not protected under the copyright law until around the beginning of the 20th century. And it really expanded what the copyright holder was able to protect in the work. So what is it? And the statute, it says a work that adapts, recasts, or transforms the original work. So already when we're thinking about participatory media, remixing, we're thinking, adapts, recasts, or transforms, what does that mean? So the case law that actually interprets this is really complicated, as I'm going to say many times, I'm sure, ad nauseum. But here's a simple example. So Margaret Mitchell wrote the book Gone with the Wind. Gone with the Wind was transformed into a film. The character of Scarlett O'Hara, which was separately copyrightable because it's such a fully fleshed out character, also transformed into the film. Then we have like the artwork on the plates. We have the audiobook of Gone with the Wind transforming the original work. And then we have this other one. We have The Wind Done Gone, which is Gone with the Wind told from the perspective of a slave. And that's going to come up again when we talk about fair use. But recasting again the work in order to bring it into a new medium. We don't have time to go into a lot of detail, right? And what is transformative for purposes of derivative works is really complicated. So I would just cabin that and have you understand that it's not that simple. The courts don't have the best, most straightforward test to figure out when something is a derivative work and when it is not. It doesn't rise to the level of a derivative work, but it's something that comes up a lot when you are using source materials in order to say something new with them. Yes?
What do you mean by rise to the level of a derivative work? You mean
like take enough,
yeah, copy?
Right, right. So do you take enough of the source material and change it in such a way that you're adapting it to a new medium, recasting it, as opposed to just using it where you take pieces of it, but you don't actually adapt or transform it in this way. And I know I'm just using the same words again, but that's because, as I said, it's really messy what that actually means. And my best way of explaining it so far has been to give this example, which is usually pretty straightforward to people. You take the book to the screenplay, you take the movie into the, you take the book into the audiobook, you might take the movie into a sequel. Those would usually be considered derivative works.
And would the fan literature also be considered derivative?
So would fan literature be considered derivative work? This depends. It's one of the dangers of the adaptive work that fans do is that it is not unlikely that some of it will implicate the derivative work right. But I don't want to say that it will or it will not because it's really going to depend on the individual work. And the last thing I would want to do would be to limit the genre. And again, we're going to get into fair use and a lot of other things as well. Yeah. So how long does the copyright holder get these rights? A long, 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 long time. The Constitution requires that there be a durational limitation on the rights, again, so that it can go back into the pool and everybody can use it again. But as is pretty much common knowledge now, right now, that's a very long time. Life plus 70 years for an original creator, 95 or 120 years for an institution. So for a lot of the new media work that people work with, the copyright term is way, the end of the copyright term is way, way into the future. Okay, so that's copyright. I mean, that's the most basic copyright 101 without getting into the exceptions, especially fair use, which we're going to talk about. So the first thing is it covered by copyright at all? And if not, it's free to use so long as you're not implicating other things that might have an impact on your ability to use it, like trademark, right of publicity, and the privacy towards. Well, how do you figure out if something is covered by copyright? As you can probably tell from what I've said, there's a lot of nuance to figuring out what expression is, what's original, etc. But one of the things is if you are working in a genre that is amenable to this, you can look for material that has fallen into the public domain. And there isn't a tremendous amount of audiovisual material in the public domain yet, and because the copyright term just got extended, we're all waiting for a lot more to fall into the public domain, but there is material that's in the public domain. And there's maybe more than you think because of the way the copyright statute used to work. Yes, Howard?
Why do you say things fall into the public domain?
Let's say...
Like a deep abyss where they disappear? Aren't they raised up to the public domain?
So Howard points out, and this is a very good point, people often say things fall into the public domain, but that does sound like they're headed sort of downhill, which is not the case at all. They re-enter our common parlance and the common pool of things from which everyone can take. Is that better? Or, as Howard would have it, they are elevated to the source material of our entire culture. How about that? Okay, good. So one of the things that I skipped over when I was explaining how you get a copyright is there's this little faded bit in the left-hand side of the slide that says formalities. Formalities are no longer required. Is so long as it's original just a little bit and it's fixed in a tangible medium, you have an automatic copyright with some nuance, as ever, in that work. You don't have to put a copyright on it. You don't have to put the copyright notice on it since 1989. And you don't have to tell anybody that you're claiming copyright. You don't have to register the work with the federal government the way you used to have to do. Collectively, those requirements, the copyright law used to require you to register, and then it used to require to re-up your commitment to the work and say that you wanted to renew it so that we all knew that you cared about it, and otherwise it would re-enter the public domain, be elevated to the public domain. All of those formalities have since gone away because the United States signed on to an international treaty that doesn't allow formalities. In the most basic sense, they've gone away. So right now, copyright is automatic. However, yeah.
What was the argument, the main argument for that?
What was the main argument for abolishing formalities? Well, besides complying with the Berne Convention, which is the pragmatic argument.
Why is it in the Berne Convention?
Yeah, so why is it in the Berne Convention? So a lot of other, I'm giving you a very US-centric vision of what copyright law is about, this economic trade-off vision of copyright. This is a very American vision of copyright. In other countries, particularly continental Europe, there are other threads of purpose behind copyright that have made their way into the law in more directly than it has here. I don't want to say that this is it hasn't made it into law here, because it has. But in continental Europe, for example, there's a very strong tradition of protecting the author's dignity and thinking of a copyrighted work as something that came from the author, and therefore, for philosophical reasons tied to personhood and tied to things like natural rights, that the copyright should belong to the person who created it, to the author, to the creator. So there's more of, there are different philosophical threads in other parts of the world that are reflected in Berne and that we have sort of signed on to in order to harmonize with everybody else. And because we actually do tend to think, we do tend to pull those threads in a little bit as well, even though our official line and the great thrust of our law is that that we want to have this, what the Supreme Court has called the engine of free expression. We give you some rights, you give us some work, it's wonderful, and eventually other people can use it too. And we continue to have lots of people creating as much as possible. But that's what I understand the basic, like.
So that the reason we lost the formality part was that in Europe they didn't ever have them?
Yeah, or they've had much formalities with much less force behind them. But actually the Berne Convention, and we hung out and did not sign the Berne Convention for like 100 years. And then we sort of complied with part of it in the 76 Act, and we didn't comply with the final part of it, which is no requirement that you mark your work with a copyright notice until 1989. So we complied with it sort of grudgingly. And in fact, the U.S. is so grudging in its compliance. I probably shouldn't say that on tape. That's not a nice way to put it. But we're conservative in our compliance with Berne to the extent that I told you that copyright law for your work, if it's original, is automatic with some nuance. Well, the nuance is you can't sue anybody unless you register the copyright. And not only that, you can't get the statutory damages, and we have these huge possible damages in copyright law in the U.S., which is also unlike the rest of the world, which tends to have much lower damages. But you can't get them unless you registered the copyright before somebody infringed it or within 3 months of creating it. So there's a lot of force behind those formalities that don't exist still in the U.S. when it comes down to practicalities.
And this may not be interesting for everybody, but just for me,
yeah.
Since I've got you, my understanding is that historically the United States pirated tons and tons
Yes.
of copyrighted material from the UK, and it was actually a huge business.
Yeah.
So we went from a country which really didn't protect the rights of authors at all, and
Right.
were pirates, to grudgingly doing it, to now passing. And so while Europe has all of these really kind of archaic, in my opinion, things like rights that
Moral
like
rights.
and like rights of people who own mountains and things like that,
Yeah.
to where now the U.S. is pushing, at least on the commercial side, a much more sort of tougher
Yes.
protection.
Yeah, and I think that's a fair description of what has happened. I mean, if you look at this slide here, I only touched on how long it is now, but what this slide does, thanks to Michael Madison, who's a law professor who put it together, is that it has grown and grown and grown and grown ever since we started granting copyrights right after the Union was formed. And compliance with Berne, the Berne Convention, was the treaty that also requires us to give everybody in the rest of the world the same protection within the United States that we give our own authors. And until we signed the treaty, we weren't required to do that. And as Joey said, for many years we didn't do that. Lawrence Lessig puts it best. He says, we were born a pirate nation. And it's absolutely true. People used to wait on the dock for the next Dickens serial to arrive on the boat, and they would shout it out and then immediately go and publish it all over the country, pissing Dickens off to no end. And generally publishers and authors in Europe, because we just didn't respect their copyrights. And our rationale for that was that we were a young country, we needed room to grow, we needed to build our economy, and frankly we couldn't afford to be paying them royalties. And of course now we go to other countries and they say we're a young country, we're developing, and we're not as interested in that now. But that is the position that we took from the beginning. Yeah.
Did they try and use like shipwrights management to keep copies out of the U.S. at all?
You know, that's a good question. I don't know enough about that. So I would really recommend, actually talk to me later and I'll recommend some history books, because there are some historians and actually English professors, as well as legal scholars who've gone and who've just told this story in much more detail, and it's fascinating, you know, sort of what our motivations were. Okay, so thinking about whether or not something is free to use. So the first question is, has it entered the public domain? And here's where those formalities that no longer really exist unless you want to actually enforce your copyright become your great friend if you are a user who wants to make use of source material. Because formalities did exist until 1978 when the 76 Act took effect, and the requirement that a work be marked existed until 1989. So that means two things. One is that there's actually a lot more work that fell into the public domain over the course of some of the 20th century because people didn't register it or didn't renew their registration than you might think. And secondly, that it's a huge mess. I mean, it's just it's absolutely complex, messy undertaking to look at something and try to figure this out. So I could not even begin to go through all of the nuance for you extemporaneously, and you would fall asleep if I did. I like to use this chart by Peter Hurdle at Cornell, and this is only one small portion of it. This is the top of several sections. He updates it every January 1st when new things enter the public domain, and he sets out, if you know enough about a work to know whether it was published, which used to be required in order to get certain terms. If it wasn't published, you get longer terms. If you know whether or not, if you can look up in the Copyright Office to find out if it was registered, if you can look up in the Copyright Office to see if the registration was renewed, then you can figure out from this chart actually whether or not it's still under copyright. And in fact, a lot of stuff is not under copyright. There's a book, unfortunately, I meant to bring my copy of an earlier edition of this book by Nolo, because I can never remember the name of the book they cite, but there's a book which is out of print, which is this entire book of movies that have fallen into the public domain because they were either not registered or the registration was not renewed. So there's actually if you can get your hands on it, there's a lot of source material that may be available with some patience and with some digging and with some good information. And sometimes that information is what is difficult to come by because the records aren't there, you don't know enough about the work, then you have this orphan work issue. Nolo, this is, I mean, there are other guides. Nolo Press makes this one. And the other reason I was going to bring it was to show you how thick it is. Again, you know, you have to put some effort into it. But if you do, you can often find a lot of stuff that's in the public domain. Yes, Steve, sorry.
I ask about, so a lot of those films that were elevated to the public domain and then have been reissued in the last few years on DVD, are those free to rip and use because the public domain, or is there some sort of secondary layer of copyright apply when they're reissued?
Yeah, so question is, what about those films that enter the public domain and have been reissued on DVD and encrypted, remastered, right, and encrypted? So for the first thing is the fact that the originality required is quite low. And there are some sort of special things for remastering. Again, in the statute, technical things that if you have a lot of money, you can get Congress to give you. So there are some limited rights in remastering. But the bigger issue probably is the fact that DVDs are usually encrypted. And because they're encrypted, in order to get to the content, you have to decrypt the lock that's on the content, and then you run smack into 1201 of the DMCA, which we're going to talk about in a minute. However, there has been a court now, the Federal Circuit said there has to be some connection between actual copyright infringement and breaking that encryption in order for the DMCA to step in. And we don't know what that means. We don't know if that, like, now we can say if it's in the public domain and it's behind a wall, you're not going to be liable under the DMCA. We don't know, but this one court has sort of maybe started to hint. It doesn't help with fair use, but it may help with that. Okay, so the NOLO book has got lots and lots of information. Peter Hurdle's chart, once you know enough about it, can give you can calculate the very messy term calculations for you. And then everybody knows you guys. I'm not going to try to give you guys sources. You're the ones who know this, but just one of my favorites, of course, is the Internet Archive with its many subsidiary archives. And they're usually pretty good about giving information around the work as to whether it's in the public domain or whether it's otherwise available for use. Okay, so if it's not in the public domain, and you're not going to use it under an exception, which we're actually going to talk about next, there is this other possibility that I just hinted at, which is now becoming a larger and larger possibility, which is that there's work that's actually been released for people to use under a generous license. Some of the stuff in the Internet Archive falls into this category, and obviously Creative Commons and other open licenses have just caused this, set of source material to explode. And so Joey's going to step in and talk a little bit about that.
Actually, first I wanted to, how many people already know what Creative Commons is and use the licenses? So it seems like everybody.
Maybe you don't need to. Is there anybody who doesn't know what Creative Commons is?
I'll figure it out as we go.
Okay.
CreativeCommons.org has lots of, yeah.
I'm just wondering if there's anything Creative Commons related that people would be interested in or would like to talk about. I mean, one of the things I suppose is, so what you need to think about when you choose a license. How many people don't know the differences between the licenses very much, and would? Okay.
There's some.
Couple. So I probably don't need the slide. So there are a number of questions that you have to answer to determine which license you want to use. So Creative Commons, just everyone knows, but just to be clear, provides a spectrum of licenses that allow you to grant certain permissions, so people don't have to ask. And so we have the core licenses, which actually end up being 6 licenses when you answer a couple of different questions and in combination. And then there are special licenses that we have for things like sampling and things like that. But the core 6 licenses there are several questions that you need to answer, and different people are going to answer them differently. Some we say are more permissive than others because it actually allows more freedom to reuse, and some are more restrictive. We don't like to make judgments about which are better because I think depending on your position, what you want to do, and what the content is, what kind of rights you want to grant are different. But you know, one of the first things that you have to decide is whether you would like to allow people to use this for commercial use or not. We call this the non-commercial use provision. So, so Creative Commons, all of the 6 main licenses require attribution. We didn't initially. We had that as a choice, but over 90% of the people selected attribution, so we have that. But the first question is, do you want to allow commercial use, non-commercial use? This is actually the hardest provision because what commercial use there is no real law about it. And what we find is that depending on the person, what they feel is commercial use is different. And we want the Creative Commons license to reflect how people feel more than anything else. I mean, we don't want to dictate what commercial use is, because basically what we're saying about commercial use is at what point do you, as an artist, feel exploited, right? So what we want to do is we want to take a bunch of people who don't want commercial use of their works because they feel exploited or something like that, or they want to reserve that right to make their own money. And then other people, like certain bloggers, would be happy to have their stuff used in a commercial way. To be honest, right now we're preparing to do a survey to try to find out what people how people feel on this issue, because we want to base our rule on that. But one of the questions, and it would be interesting to see a poll of the room, is if you run a site which isn't making money selling, so let's say you make a video, right, and I put it on my site. If I'm running ads, so I'm not selling the video, I'm not packaging the video, but I'm running ads on my site, and let's say I'm a blogger, right, do you feel that that's commercial use or not? Because there's a commercial transaction happening around your work. There's money being made. So YouTube runs ads, right?
Somebody comes to YouTube because of the content.
Exactly.
And then Google gets money from it.
Google gets money, and you're not getting a share of that. Now, the rough number right now is about half the people feel exploited when they see an ad next to their work, and half the people don't. And this causes a dilemma for us, because we can't say clearly either way, because then half the people will say, well, that's not my definition of non-commercial. And then the other thing why it gets complicated is that depending on the community, the sort of norms may be different, right? And so this is actually something that we're all discussing, and we're going to be doing a survey on this, and so people's input, especially if you're like in the vidding community or the AMV community, it would be interesting to get people's input. We may end up having to, there are really ugly solutions to this, which would be to make another split in the license so that you get to choose ads or no ads. But this is actually one of the issues. Some people say that using the word non-commercial is really stupid. The reason why we use this, and tell me if I'm giving you more information than you want, but in open source, what they use is basically, in order to modify the work and to transform the work, you have to sign into this license, like the GPL. You have to agree to give back any changes that you make. And that basically prohibits, it makes it so that if somebody's going to exploit you, they have to give back, right? Mm-hmm. And the trigger for that is a transformation, is editing the material. The problem with creative content, like photographs or music, is you can actually exploit it more easily without actually transforming it. So you put it on a CD, you just put it on the wall, and it's exploitive, but it doesn't get triggered by this transformation. So by saying, oh, you can't edit it, well, so that's why we're using this word non-commercial, because we found that among creative people, commercial use and non-commercial use seems to be one of the triggers for feeling exploited or not. Okay, so anyway, that's probably more than you wanted to know about non-commercial, but
well, not me. I mean,
okay.
From a lawyer's perspective, this is one of the central questions, right? Is what does, as you said, the case law is not helpful. Like, we really don't know what commercial means. We don't know what non-commercial means, and that means we don't know how to treat YouTube It means we don't
Right.
know how to treat. It comes up again for fair use.
Right.
When you're thinking about whether the use you're making is non-commercial, right? The courts look at that, but they don't necessarily apply
Mhm.
straightforward criteria. So having the community's perspective on that
Right. I mean,
is going to be really
can
valuable.
I get a raise of hands of how many people feel that ads would constitute commercial use?
And how many not? Wow. It's
So
more,
so
more
so
than
so
half.
that's but what about a blogger that's running AdWords?
Well, yeah, that's right. So
Right.
who's running the ads? I was thinking of a blogger.
Right. So I mean, there's also the non-commercial user, like a blogger that's running AdWords on the site. Do you consider, would that be, and somebody's using your work in their blog, would you feel that that's also non-commercial use?
That's the same, it's really,
Right.
it's Google running the ads on their blog and your thing is part of their blog.
Right, but they're getting paid
But
by
Google's
Google.
making significantly more than they are, right?
Right, but that's like more or less, right? So we're kind of like, you know, it's like half pregnant, you know, it's like, that it's, it becomes, I mean, so I guess the answer to this is it's, a lot of this stuff, and as even the copyright stuff, is it's not technical, it's, a lot of it is emotional, right? And, yeah.
Well, just so we make sure we're on the same page, it doesn't matter if it's online or if it's at a fundraiser or if it's on television, right? This is not just about online.
This is not just about online.
Right.
So if this video is being shown online, I think people have different opinions than if it's being shown on television, and they have different opinions if it's being shown.
Right,
to raise
absolutely.
That's a really good
to raise
point,
money.
yeah.
That's absolutely correct, and you know, and then there are all these little other side paths, like what about an educational institution, right? What about if the educational institution is a private
Fundraising.
school or a public school, you know, and fundraising, and so the difficulty, and what we're probably going to have to do, and I'm not, this is an official position of Creative Commons, but my personal opinion is that we have to have a community conversation. We all have to have kind of a consensus, and then we kind of have to buy into that. And it's not really, and I think at least in the United States you have common law, so that could lead into laws being sort of supportive of that. But I think what we really need to do is figure out what that is. And the problem with this one really is that it is so split that it's going to be a pretty difficult conversation. So when you, yeah.
I think the key is, my background's in poker, and in poker you say it depends is the answer to every question. And you're using the word blog as if every blog's the same, and I think it's really important.
Right.
Right.
To know that there's a scale of
Yep, absolutely, yeah. And you know, so like there are a bunch of little, there's, for instance, in the wiki, the Creative Commons wiki, there's actually a work in progress, like a cheat sheet on non-commercial, and asks a bunch of questions, you know, like are you, what kind of institution are you making money directly? And these are things that people have pointed out as things that make them lean one way or the other on feeling whether it's commercial. And as a blogger, it would be, you know, is that your, are you a professional? Are you?
what kind of blog is it? Are they trying to make money, or are they good people that happen to have a couple links? That's it.
Right. But the part you don't want to get involved in too much with the copyright, I mean, with Creative Commons at least, is when you start stepping into what we were calling moral rights. Like, well, I don't mind Christians, but I don't want any Nazis using my work. But then that gets into a whole different set of rights. Where in Europe you have moral rights and the ability to prevent people from doing that. But that's kind of beyond copyright. But so anyway, the first one, non-commercial or no, is probably one of the hardest ones to decide. My personal argument to most people is that unless you're a musician who's trying to make a lot of money on commercial licensing, but if you're like, say, if you're an amateur blogger, and the main reason you don't want commercial rights, people to use it for commercial use, is just because it doesn't feel good. I try to argue people out of using non-commercial because I have a television show in Japan, or I used to, and we use all attribution and public domain work. So any attribution non-commercial stuff would never show up on our show because we didn't have the time or energy to go negotiate that. And when we posted, whenever we use music or screenshots, we'd put their name in big bold letters at the bottom of the screen. We give them credit. We give them links on the page. I mean, I think generally speaking, most of the people stuff that ended up on our show benefited from the attention, right? And what you'll find more is stuff that's tagged with non-commercial, especially if it's a larger network or a larger organization, they'll err on not using it because they don't want to have you come back at them and say it was you're using it for commercial use. So if your purpose of what you're creating is just to get it out there, the non-commercial use, while you may envision somebody printing out your whole blog and selling it on Amazon, it's less likely to occur. That kind of exploitation is less likely to occur than, yeah.
So what are the actual numbers? Like what do people actually prefer?
Yeah, I can show you the numbers. There's a very interesting statistic, by the way, which is that year after year, people are becoming more permissive. So the interesting thing is a lot of people start out with very strict licenses, and then they start switching because they realize that what the reason they're doing it is to share, and the restrictions are holding things back. Let me see if I can get.
There's a down the line under.
Okay, I've got.
So I would be curious about the overall numbers and then how the numbers shake out between people who are actually commercial creators, who are actually aspiring to make money off their work
Right.
versus those who aren't. I mean, as academics, we're somewhere in the middle where we actually don't make money off our publications. I mean, we make peanuts off our publications. That's not what pays our bills. But we would be really pissed off if somebody took the articles we posted on our blog and published them in a commercial press. That would be annoying. And that's why I always pick non-commercial, because I don't mind people printing them out for their classes or something like that. But so I was sort of curious, just if you have numbers. I guess you don't actually know.
We don't have.
You don't have the user background.
No, and I'm having a hard time finding the actual presentation. But I'm sorry, I'll look for it.
I mean, the other issue on commercial, non-commercial that must come up is that you have people who are using something, who create something in a non-commercial setting and then end up making money off it down the line in
Right.
unexpected ways. And I guess Creative Commons can't really do anything about that, but
Yeah.
there seems to be so many contingencies in that kind of decision.
Right. There's a long discussion that we've been having with a variety of rights collection agencies and artists about limited term licenses. And we don't want to do it, by the way. But we're still kind of open to the conversation because a lot of people say, well, I don't know what's going to happen later. The problem with limited term is that it just is very complicated, and it's restrictive. And you know, one of the good things about Creative Commons that we're trying to do, well, sort of theoretical part. So I was also on the board of the Open Source Initiative, and one of the biggest projects that we had at the Open Source Initiative is there are 500 open source licenses, and they're crazy, right? And some of them suck. They're basically incompatible with each other, and it's really hard to choose, right? And license proliferation is a really, really big problem because if we had 10 different kinds of TCP/IP, the internet wouldn't work. So a lot of people will criticize Creative Commons and the free culture movement and stuff like that as being kind of imperialistic. We're like trying to push this American license on everybody else. But well, you can be creative when you have a certain amount. The fact that Wikipedia doesn't use Creative Commons yet is a big problem because you can't mix those two pieces of content. You can't use a Creative Commons share-alike site and drag Wikipedia content into it. And so there's a huge advantage, especially with the share-alike licenses, in having the same license. And so what we're trying to do is we're trying to get people to have as few licenses as possible, even within Creative Commons, and to not make their own licenses. And the OpenCourseWare people, I mean, I find a lot of universities making their own licenses, you know, or wanting to modify the Creative Commons license. And it's really, really a problem because, and the other thing is just from the user's perspective, you don't want to go through and have to read all these things. and even from courts, if Creative Commons license starts creating precedents in court, it's easier for a lawyer. Well, you can tell me if this is true, but it's much easier I think.
It's not only, first of all, it's easier to end up with precedent that you can then just apply down the line, but also I think it's important from the perspective of the courts to understand what the social pact is, at least in the U.S. and in other common law countries that actually use courts to look at these things and don't have things just in statute. So I think of open source licenses in part as a social compact that describes the community's norms and what the community has decided is okay. That's a really powerful thing. And it's a powerful thing even if you never get into court, because the incentives for people to sue each other and get into court are fewer if the shared understandings are there. So both, that's courts, you can't always, you can't predict them entirely, but they like shared understandings, and it helps their decisions be stronger. And then having fewer sorts of options means that when a court holds something on a Creative Commons license, then you can apply it, because you can apply it to that Creative Commons license down the road. But you can't apply it to, generic XYZ license that somebody else has come up with, because the court didn't rule on that. The court ruled on the Creative Commons license. And you can try to analogize, but you're never going to be sure. So yeah, it's valuable.
Thank you.
Is there any legal precedent yet with Creative Commons in terms of anything going to court?
So I'm not the expert, but there's one. I think there are a few. The one well-known one, which is, I'm sorry, I couldn't find the chart, but I think I'll send it to you. One of the famous ones was Adam Curry. I think it was in the Dutch court, right?
Yeah.
Or do you want to describe this one? Do you know the?
I don't know the detail, but again, like there have been courts in other countries, particularly this German case to the GPL, saying that it's enforceable. But it's really hard to translate that back outside of that country and into the United States, and it's particularly difficult with Germany, because Germany is a continental law country, which means they really rely on what's in their statute, what's in the text of their statutes. Whereas we have the common law sort of courts interpreting things, so it makes it difficult to apply here. But it does mean, that there have been courts that have certainly, been willing to enforce these licenses.
Yeah, the Adam Curry one was basically the attribution license, attribution aspect, where a mainstream media, I think magazine site, used one of his photographs without providing attribution, and they were able to enforce that. And I think that's also important because the Creative Commons licenses, a lot of people, like especially in certain circles, think of Creative Commons as giving it away, right? But in fact, Creative Commons licenses have a lot of requirements, like attribution, which are fairly strongly stated in 49 jurisdictions and in their local language. And so those are the things that I think are also important, is when you are using Creative Commons license, you're being very clear about what you want. And one of the problems that a lot of people have is they say on their site, oh, go ahead and use this, or give me credit, but those aren't legal terms. And the problem is when you try to go to court, then you're interpreting what you said, and having that legal text after it makes a lot of sense.
What did you mean when you said go ahead and use it?
Right.
Well, I didn't mean commercial. Well, what did you mean by commercial? And
yeah,
it gets messy very quickly.
So the other questions that you need to answer. So there's the commercial, non-commercial. I don't know if did we finish talking about that? So and by the way, so the non-commercial use license part of it that I think makes the most sense are musicians who are using it to say, I'm not going to try to collect money from my fans, but I will want to collect money when it's licensed by a movie or a commercial or packaged into a CD. And actually that's a fairly large portion of the music industry. So by giving away the non-commercial use, you're still, I don't know what the number is, I think some people have said like even 40%. I mean, you're still retaining a large part of what the income that you could possibly get, and especially if you're a musician who has no way of getting your music out there, then giving away the non-commercial use and allowing people to put it onto YouTube and things like that, onto videos, is actually a good way to promote your music. So that protects you there. The other element we call share alike, which is similar to copyleft, which is like the GPL versus other open source licenses. And share alike basically means that whatever is created, if it's being transformed, has to use the same Creative Commons license. Basically, it means that whatever is made using your work, you can use too. Now, again, this would be prohibitive to, say, a television show, because a television show is not going to give you the right to use the whole show under a Creative Commons license. They probably wouldn't have the right to give you that right. And so while that's great for community work and developing a body of the commons, and it is a really strong tool to force people to throw things back into the pool, it eliminates a certain kind of channel and distribution channel for your own work. I think that a legal journal, for instance, would not use a share alike license. And tell me if I'm wrong, that it would cause a bunch of that journal to be used, right? Or can you get around that?
So actually, I think the fourth example you just gave about an audiovisual work, that's really forceful, and I didn't go into it. I mean, I gave you the mapping, and I should have made this more clear. Is that the idea is to help you understand all of the many different copyrights that are collected into a single work, particularly something like an audiovisual work, which has music, it has somebody was a screenwriter, somebody designed the sets, somebody and somebody was the director and all this. And a lot of those people maybe don't have copyright. It was all controlled by the production company. But the production company also may very well have licensed some stuff. And so they don't even necessarily have the right to put things under Creative Commons licenses. And this happens to a lot of creators, who would maybe like to do this, but they aren't actually able to because they don't have the rights themselves. And for a legal journal, you'd immediately sort of run into that because there are so many different contributors that you'd have to,
right. Yeah. And the only weird thing, which I would like your opinion on, is I think that there's some people who argue that, like a photograph inside of a Wikipedia article, is not a transformation. So
putting the photograph and surrounding it by text is not a transformation?
Yeah, and so in fact those are two separate things, and some people say they're not. I mean, so I guess we shouldn't necessarily go in. It's a detail, but there are some arguments about what constitutes where does this work start and the next one begin?
So this is the question of when you've created a derivative work versus when you've actually have disparate elements together, or you haven't taken enough, or you've done bits with elements of the work that don't rise to the level of recasting the entire work, and it's a mess. It's really complicated. Then you get into the question. I mean, there's the other transformative question about whether it would be fair use. If you're recontextualizing that photo by putting things around it, is that transformative for purposes of fair use? And again, we're sort of waiting for the courts to answer those questions in some contexts. Our local federal appellate court has said that indexing the web, so copying the web in order to create a search engine, at least in some circumstances, is transformative because you've actually changed the purpose. But that's one example, right? And that was a really new way of thinking about it. So the question of whether surrounding the picture with text would be transformative, copyright lawyers would argue about it, and they'd want to see every example.
Right. So, yeah.
What's the name of that case that you just said?
The Ninth Circuit case. There are a couple. There's Kelly versus Aribasoft, which is the first one, and now we're in the middle of Perfect 10 versus Google. And again, I haven't given you all the gloss, but there's sort of the Perfect 10 is a company that produces pornographic content and has really been trying to enforce its rights against a lot of different parties, including Google for imaging, for indexing, and then making thumbnail images in the search results. And also, they've sued the credit card companies for facilitating the transactions of people infringing their material. So there are a lot of Perfect 10 cases, but Ninth Circuit Perfect 10 Google is the one I'm talking about.
so to get back to the license part, typically I would say you should use share alike if you're likely to want to reuse stuff that's done with your work. So if if you're a musician who's making, a DJ who wants to see what people do with that work and then reuse it, share alike is useful. But if you're trying to have your stuff picked up by mainstream media, that's not necessarily a good one. Yeah.
So there have been a couple cases, I think, where mainstream media has actually picked up material that is share alike,
Yeah.
and incorrectly used it
Yeah.
without, offering
Right.
share alike.
Right.
In that case, could a third party then use the material from mainstream media and say, argue in court, oh well, I thought it was share alike because it's using this originally share alike.
It's interesting. It's a good question.
Sort of imagine-
Could you
I mean,
enforce
you could obviously argue it, just like you can argue fair use. I think the question. I mean, I don't know. You don't want to give legal advice, but it would be fun to try.
It sure would be fun to try.
It
Yeah.
sounds kind of hypothetical, but imagine a world in which major
Right.
news services are getting
Yeah.
photographs and video from
Yeah.
everyday people constantly.
Right.
Well,
And that would sort of force their hand.
and in the Free Software Foundation, the sort of home of the GPL in the software context, they claim pretty high degrees of success by just explaining the situation
Yeah.
to people and saying, we could sue you and say, it's
Right.
time, you have to let all this go, so it's time to comply with the license.
Well, there are a couple of pieces. Let's tease this one
Yeah.
apart because it's actually an interesting problem. So the current Creative Commons license doesn't cause the person who's putting the license on to have any, they don't bear any risk they don't guarantee anything. So I guess another way of saying it is if I license something under a Creative Commons license, somebody uses it in some way that damages somebody upstream from me, I'm not liable for that use. I'm only liable for what I've done with it, right? So if a mainstream media company uses a Creative Commons license that has share alike or something and somehow damages you and that created this thing, you can sue the media company for your damages. But if I then go and say, oh, it has share alike, I'm going to do this whole thing and do all this other stuff, I think that the liability, it's slightly weird, but the person who's doing the damage is mainly liable for the damages themselves, right? Not the
Yeah, so I don't want to go into a lot of detail on this, but this is the chain of liability issue with licenses that have these sort of continuing chains of users is something else that the courts have never confronted, and that is really complicated to think about, and it's a little
Right.
unclear what might happen.
And I guess the answer is they can still sue you,
Yeah.
but you have an argument because at least in the license it says I'm not making any guarantees or warranties about what I'm using, right? Now, having said that, Creative Commons was recently sued by a photographer whose work was used by Virgin Mobile.
Oh, really?
Yeah, and so what happened was there was a Creative Commons license work. Virgin Mobile used it in sort of a derogatory way. The family of the girl in the picture sued Virgin Mobile. The photographer sued Creative Commons. It was dismissed because it was actually the suit was about privacy and wasn't about copyright. But the argument that they were making was that Creative Commons was sort of misled the photographer into thinking that he had the right to do this and so on. But the reason I'm pointing this out is they can sue you for anything, right? And even if you say in big bold letters inside of the license that you don't have risk, you can still court could end up saying that you're liable.
Right. Yeah. You can't. You can make no warranties, and there's some extent to which that would be enforced, but you can't just say I'm not liable and not be liable, right? Which makes sense if in a broader context.
So probably in your case, what would happen is if you went to the mainstream media company and you said, well, you're using this license improperly and blah 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 blah. Probably what would happen is if they were smart, they would settle with whoever felt damaged, but they wouldn't then. You couldn't really sort of judo them into releasing a bunch of stuff that they didn't have the right to do, right? I would guess is how that would play out.
Basically they wouldn't be able. They wouldn't be able to release stuff, stuff. If part of the underlying work they didn't have the right to release. So, it would be a question of whether they could compensate you with money damages.
Yeah.
or if the whole thing just gets pulled.
Right.
Which is, if you're not a big media company, that's what happens.
Yeah.
But this is a related question, but if, I guess I'm just wondering how much in the share alike clause, how much of the derivative work is considered the derivative work? Like you said, if a TV show uses a segment of your video piece, or if a newspaper uses your photo, would the implication of the share alike license be that entire issue of the newspaper, or that entire half-hour TV show be share alike, or that entire movie, or just that?
So that's kind of, that gets to my thing about the photo. It's like, where does the work end and where does it begin? And there isn't, I don't know that there's a
This
really
is the
good-
derivative works issue. I mean, it's slightly turned inside out, right? Because I was describing it from the perspective of somebody who's using source material and maybe creating derivative work, but here you are the Creative Commons licensor and somebody uses it and maybe creates a derivative work. And where, you know, how much is the work or how much is the derivative is this, you know, really messy question that I don't know of any good answer.
And-
So,
yeah.
like, in a hypothetical situation, what if it's used on a billboard, like a Virgin Mobile one, can then, if Virgin Mobile had really done it intending to use the full share alike clause, would that mean that they're then releasing, like, their logo and any other images on the billboard? Or, and their logo is obviously trademarked, but what does that mean?
So that's a question for, I mean, the Creative Commons licenses, I only talk about copyright as
Right.
far as I understand them. So this is why I had at the bottom of the slide, you know, we're talking about copyright at the moment, but you cannot forget that there are all of these other legal regimes that may affect the situation. So trademark is a big one. Right of publicity, using someone's identity in a commercial sense or in a way that impacts their privacy in some states. In the U.S., that's something else that comes up. And then general privacy, defamation issues. Those are all still there. Copyright doesn't just wipe them away.
So is the fallout that after this Virgin Mobile case, you're not going to see share alike pictures on billboards?
Well, I don't think, so I can't really speak on behalf of Creative Commons because I'm not the GC, but I would say that if you're, I mean, you should be very careful about using share alike content in anything where you're not willing to give it up. I mean, it's share alike I think is a very specific kind of license that people, maybe things like, it's hard to describe, I mean, but like a group of musicians or somebody who's making a collective work on a wiki, that doesn't need to get mixed with a bunch of other stuff. Those kinds of things I think make sense. But if you're making a work, you know, that might end up on a billboard, like a photograph, share alike is not that useful because you have it makes it awkward for people who are like trying to do a billboard. And then what is this case where it would be really useful for you? I mean, it's like because I can see why you might want to prevent somebody from using a photograph, but if you're allowing somebody to use a photograph, what kind of derivative of your photograph would you so want to have access to that you would prevent other people from using it, right? I mean, or maybe you have an example, I don't know.
Well, so I think about creating, eventually selling a DVD of compilations of derivative works that people have made from the
I
video
see.
that I've produced.
Right.
So the share alike would be useful in that case. But
Yeah.
at the same time, I don't want to see specific types of uses of derivative works like billboards or
Right.
commercials.
Yeah, and I think in that case it might work for you. I mean, because the share alike would probably, if you had a conservative, especially a conservative legal team, they probably wouldn't want to use a share alike on something that's, you know, like a billboard. I mean, that would be my guess. Would you?
No. But again, like these sort of the chain questions,
Right.
they're really, really complicated. And the only thing that I would suggest is to really, you know, think it through carefully, which is not the best.
Right.
You know, it's not as concrete the advice as you would probably like, but it's kind of the best that I think we could do in this sort of situation.
And
Well, so I wanted to ask a slightly different order of question, which I hope isn't too far afield from the pragmatic mandate of this panel. But Joey, there was something you said, I think it must have been in that when you were pitching Creative Commons to the suits at Disney Channel, and there was something you said that I just wanted to clarify. I think it was, I found it provocative and counterintuitive, and I want to make sure I got it right. And if I did, I think it'll be something that people will find interesting. If I understood you correctly, you were saying that Creative Commons was approaching a moment, if we weren't there already, where it needed to transform from being kind of a social movement, a movement, to being a technology. And for me around here, like, we had, a student who was so excited by Creative Commons that he started a free culture group, became the intern at Creative Commons, Cameron Parkins, and it's like picked up some momentum as a social movement here in what are really interesting and powerful ways. And it's like, I don't feel like I'm ready for it to let go of it and have it become a thing that's written to technology instead yet.
So there will always be a community element because we need to discuss norms and stuff like this. But I guess what I meant was that, so the internet, while the beginning of the internet wasn't necessarily a movement in the same way, the protection and the idea of being open is fairly political and fairly emotional, and there was a big fight between the sort of telephone company run X25 networks and the rather open TCP/IP internet networks, and the telephone companies lost, right? And so now we all use TCP/IP. Even Republicans use TCP/IP, and so but the fact is the internet's great because we all use it, and it's ubiquitous. And in the DNA of the internet, there is this DNA that forces it to be open, right? It's the same with HTML, view source, right? That's great. So even if George Bush uses it for his web page, you can still read the whole thing because they're using an open standard and an open technology. And the value of HTML and TCP/IP is in the fact that it's completely ubiquitous, right? So what I was trying to say was that Creative Commons now, it started out with a bunch of liberal law professors saying, wouldn't it be cool if, right? And it was an idea, right? But at some point, it's really, really useful when everybody's using it, right? Because what you want is you want Google and Yahoo to feel that it's so ubiquitous that all of their users want to use it, and instead of having to dig into the advanced search button, that it's actually, tagged all the content on the site. And for that to happen, it's really got to change from something where the liberal kids are wearing it on their T-shirt, or you use your knowledge of Creative Commons to pick up girls in bars in San Francisco, to something that's a boardroom conversation at Disney saying we need to do this if we want to increase our market share. Now if you go to the Wikipedia article on Creative Commons, there's a criticism saying that Creative Commons is a tool for corporate co-option, right? And so you're going to start losing some of the support of the more liberal free culture movement, who kind of is very much like at odds with the commercial part of the world. But my feeling is that unless all of the big web companies, unless the Nokia phones have it built in, unless Hollywood is using it, we haven't really done what we need to do, which is make it available to everybody, right? And I think that's kind of what I meant. And I guess I meant that I was trying to get Creative Commons to become a technical infrastructure that would be a no-brainer. And I think the best example is when you sit down with Nokia and you say, you need to have this as a selection in your phone. They think, okay, well, what's the market share of it? How much is it going to help the user experience versus make it more complicated? And I think that it would add a lot to the commons if people were tagging their photos with Creative Commons licenses automatically when they were taking the picture. But that's a trade-off, because then suddenly it's not as cool anymore to know about it when everybody's using it.
But that's, a legal framework should be that. It should be a framework. It should be a foundation. It should be something that supports what is going on in the culture. And you can't divorce legal frameworks from politics because of course they're intrinsically related. But it is the code. That's really what it is. And it probably things would move forward faster if you thought of it. This is the code.
And that's why we've sort of split off iCommons and Creative Commons. So Heather is in the iCommons movement. That's kind of the movement part is part of the summit and all of that. And Creative Commons is trying to focus on the more legal porting of the code aspect of it, because I think people still want the movement, but we can't. And the meetings are getting exceedingly difficult because, for instance, even in Rio, we had Microsoft had made a Creative Commons plugin, you know, and some people are shouting sell out, you know. But to me, that's a good thing that Microsoft feels that there are enough people now who want to tag Microsoft Office documents with Creative Commons licenses. There's also another interesting series of conversations of people saying things like, well, Flash, Open Flash, I mean, sharing among Flash developers, that's like bad because they're on top of a proprietary platform, you know, or people will say MP3 is bad, use OGG because MP3 is proprietary, and so how could you, or Lessig uses a Macintosh, that's a sin, he should be using Ubuntu, and so there are a lot of purists in the free culture movement, which I think is important actually. I don't want to diss them too much because if it weren't for Richard Stallman, we probably wouldn't even be here having this conversation. And there are people who put stakes in the ground and draw lines in the sand, and those people are really important to create the sort of frame in which we are doing our work. But I think but Creative Commons is not about, so I would characterize it like the Free Software Foundation is about sort of creating a choice to be in the free side of the world, right? Whereas we're trying to allow everyone to have the choice, whatever choice they want to make, rather than the choice of us or them, you know. And I think both are valid arguments.
So I think that we maybe should take a 5-minute break and come back and maybe talk about fair use. Do people have other questions on creative? Yeah, Jonathan.
I just had a quick question about it. I mean, people who do remix work, whether that be Cinema or AMV or Remix, do we want to tag our videos with Creative Commons licenses even if we don't own any of the source material?
So,
well, so I think what you should do, I mean, I can give specific advice on this, is that you can always write stuff underneath the, like I often say, you know, like everything on my site is Creative Commons unless otherwise noted. Or you could even say this whole video is Creative Commons license except for these 3 things that I don't have the rights to. You know, you could say that if you wanted to. I don't know if you'd want to, but and similarly, I think what more and more people are going to start saying because of this Virgin Mobile case is, you know, it's Creative Commons licensed, but you know, you don't, you know, watch out because you know there are moral rights and other rights, and so you could easily say that I'm Creative Commons licensing everything that I have the right to Creative Commons license, which is a copyright to the creativity that I've contributed, right? So you could, I don't know how you would tag it specifically, but you could define that remix part of it and Creative Commons that. Now how to tag that would be, I mean,
I probably can't be too specific, unfortunately. But a license is effective as to what you actually have the rights for, right? So it has nothing to operate on if you don't have the rights for it to operate on, right? So, you know, one thing that people could think about doing would be to say Creative Commons for everything to which I own the copyright.
Right. And I think that
or control the copyright.
What you would get sued for, if you got sued for, would be misleading somebody into thinking that they could use it when they couldn't. So as long as you wrote it in a way that wasn't misleading, although they could always argue that it was misleading, that would be kind of the litmus test. Is if somebody was looking at it, they would know immediately that this footage they couldn't just excerpt, you know.
And it's not really just a legal question. I mean, you really don't want to mislead people.
Right. Exactly.
Right. Yeah.
And a lot of people just go around looking for Creative Commons marking because they know that they can then incorporate that in their own material.
Right. Right.
You don't want to.
And I think that's the big homework project for us, is to start making it clear to people that just because it says Creative Commons attribution, it doesn't mean you don't have to get the model release forms or whatever additional rights that you would actually need.
I think this is a related question to that. So let's say I take a photograph of someone where I haven't gotten their permission to do anything with it really. I'm just taking their photograph and I put it on Flickr and I give them a Creative Commons license. Have I incorrectly given a license because I didn't have the, you know, where is the privacy
right.
rights and there's something I don't understand.
So again, I'm not a lawyer, so I can't give real legal advice, but when you're putting a Creative Commons license on a Flickr photo, all you're saying really, if you read the agreement, is that you're giving people the right to your creativity, which is that capture, right? but you're not giving any other rights. And so, for instance, I'm actually about to publish a book of my portraits, right? So I'm going to go and get a model release from every single person in my book, but I'm also getting a model release that says anybody who uses my photo also has the model release. And so I'm doing sort of a Creative Commons-y version of a model release form, and I'll give copies of this to everybody eventually once we've like nailed it down. But so really what you need to do if you're going to be formal about it, and again, in certain countries you can't even, model release doesn't even release you of the right. I mean, they still have rights in certain countries. But generally speaking, especially in the United States, if you've got a proper model release form and you attach it to the Creative Commons license, so what I'll do is I'll scan all the model release forms, I'll put them on a website, and I'll put the whole book online. So then when you can download the book, you also download the model release form that says, this photo I'm also allowed to use for other things. And then finally those photos become free. And without that, you couldn't. And the model release that I'm making, I'm also saying that you can't use it for packaging or advertising. So I'm limiting it. So you can use it for commercial use as long as you're not using it for endorsing products and things like that, which I think is kind of going to be the exploitation line for a lot of the people in my photos. But that's the whole new area that we're working on actually a lot, which is trying to create additional not standardized, that would be the wrong word, additional sort of examples that people can use to try to nail down the other rights so that actually,
Yeah, I think this is incredibly important to have those, like, I know on the site there's already a lot of examples that are illustrating sort of giving people a context, a behavioral context to it, because I think looking at just the rules is really, it really is impossible to make a decision just based on looking at the rules. And I feel like, you know, even with this event when we were trying to figure out what we could screen and not screen, for example, which isn't, I mean, it is related to copyright, but, you know, a lot of the stuff, you know, like Jonathan mentioned, isn't stuff that the editors have copyright over anyway. And so it's really an ethical issue about permissioning and, like, using people's images in appropriate ways. And there were some videos, like, I talked to Tim, and, you know, the practice in the AMV community is that, you know, people show this stuff all the time, and it might be polite to say something, but people don't necessarily even expect that. So that there's all these different practices, and there's very little consensus or ethical guidelines about reuse and redistribution about this stuff. And I know that it's not necessarily incumbent on Creative Commons to do all of that, but nobody else is, you know, in a global way. It's negotiated community by community, and it's extremely difficult when you cross boundaries of communities to have any kind of ethical guidelines. So, like, AMVs and bidding have completely different standards for distribution of their work.
right. But the problem is it's kind of like copyright is the easiest thing to deal with because it's almost the same in every country, and Creative Commons is like the little aspirin that deals with a problem in copyright, and it's like you're talking about a cancer clinic, you know, and so
Well, that's what we need.
you know, and it is kind of an interesting thing. I mean, because you sort of taste what it's like to then have all this stuff, but in fact, there's tons of stuff that will never really. I mean, like moral rights and some of these, like there's certain rights in certain countries that you can't even sign away. You know what I mean? And so there's a legal part, and then the social part. Even within the country, you have so many different practices. But then if you go global, there it gets even crazier. There would never probably be a consensus. And so it would be interesting. I mean, I would sort of throw it back to the sociologists on the right way to sort of investigate and communicate and talk about this stuff.
I think that's where, like, there needs to be a lot of work, and I do think that academics in different domains and policymakers doing, plus people doing fact-finding on the ground, kind of have to work together on this. Like, I think an example of this kind of normative stuff you saw happening around stuff like camera phone use, cell phone use in public. There was a huge amount of public debate about what was appropriate. And even though there's always people who violate what is normative, it's not a legal consensus. It's a moral
So everything is changing so quickly as well that it's hard to understand what the norms should be. So Deirdre Mulligan at Berkeley has been doing a lot of really interesting multidisciplinary work about ubiquitous video, basically surveillance by default in public places, and issues of things like camera phones. All of these, we are all so able to record one another and remix and put it up, and we really haven't developed a lot of norms around that outside of small communities, as you said. So I agree that it's extremely important to be thinking about it, have the conversation, and try to develop some of these ethics, but I'm not quite sure that people are I don't know. I mean, I'm not the expert. Deirdre and others would be the people to look into their work, because it's, it's changing so quickly that it's hard to know how the norms are going to shake out.
Well, it takes a certain amount of time for them to
Yeah.
In any case, those social norms have to come from the community outward. They aren't going to come from outside the community inward. They can have facilitation from the outside, and some examples from the legal area are what the Center for Social Media has been doing about what are common practice for documentary filmmakers, what is appropriate, what is not, what is common. Now they're working on common practice for remixing. They're also working on common practice for dance, photography, documentaries. But they're just being facilitators. The people, it has to come from the community itself, and it can change and morph, and it will change and morph. And maybe there should be someone who's kind of collecting these manifestos or morally appropriate practices from different places, but those have to really emanate from the communities.
Well, I go back and forth on that issue, actually. I mean, I do agree. I mean, I'm an anthropologist, and what I do is document the community practices around these things, so I do believe that. On the other hand, I think nothing has been established as a social norm without interaction with institutions, and that it's that dynamic interaction between this sort of bubble up viral behavior and the institutionalized forms that really make these things stick. So, for example, we've been studying sort of the use of mobile phones generally in public places is a thing that was a huge social controversy in Japan about 10 years ago. The U.S. is very late on the trajectory of developing appropriate social norms for mobile phone use in public places, and a lot of people thought, well, it's just because Japanese are polite, that it came from the culture. But no, if you look at the history of it, it was about very rigorous enforcement on the part of public transit agencies. You cannot get on a bus in Japan if you're talking on a mobile phone. I mean, it was very institutionalized enforcement, posters in trains, announcements at every train stop that enforced a social norm that was in the culture, but that wasn't, it was responding to what people believed was socially appropriate, but it was the enforcement of it that kept the antisocial people, so to speak, in line. And that's the piece where I do think that institutions have a role to play. I mean, plagiarism is another good example where academic institutions have been really central in enforcing what the boundaries of appropriate use are. Even though if you polled, the culture at large, there would probably be broad agreement, but there wouldn't have necessarily been adherence, I think, without the force of institutional enforcement for a lot of these things. So I go back and forth on it all the time, because with something as complex as copyright and distribution of visual material, it's not as if those social norms are really clear or crisp. But on the other hand, I do think that there is some role of educational institutions or, loosely knit organizations like Creative Commons to shape what that looks like.
All right, I'm going to enforce a break now. And it's a nice segue into fair use and some of the best practice standards when we come back. Maybe 10 minutes if everybody can grab. I'm going to grab some coffee. So I really should know better by now. First of all, I can happily talk about copyright for 3 hours. I'm slightly embarrassed about that, but I in fact can. And announcing that we're going to finish, in time and cover everything is exactly the thing to jinx it. And so we have about an hour left. We have a little bit more than an hour left. And Joey and I were thinking that one thing that we could do would be to sort of poll the room and see which you wanted to delve into most. Joey has one more thing on Creative Commons, and then I have some stuff on fair use, which is usually something that people want to talk about, but maybe you feel comfortable with it and you don't. And then I have some stuff on the takedown process, how it works when YouTube gets a notice and takes material down, how if, for example, you're a blogger and you have people post things in the comments, how you can also take advantage of the limitations on copyright liability that the intermediary companies get, so there's that as well. And then a little bit on the other section of the DMCA 1201, the one that I mentioned before that makes it illegal just to crack the encryption to get to the source, and then there isn't a fair use exception to that. So those are sort of the topics we have left. If folks want to kind of chime in, I mean, we can cover them all, but we can't have as long a conversation about all of them as we've been having. So what would you like to talk about?
Fair use.
I heard fair use.
Could you just spend 2 minutes in the looking at fair use of explaining what a trademark is and how that relates to copyright?
Sure. Yeah, I can talk a little bit about trademark as well. Okay, so Joey, do you want to go ahead and others dissent?
I was interested in all of those topics, so
Okay.
I could easily stay for 4 or 5 hours. But
Okay, all right. So Joey, you want to continue with Creative Commons for a second, and then
Yes,
we'll talk about fair
I'll
use.
just finish. The only other question that you answer on Creative Commons is no derivatives, which is, do you want to allow derivative works or not? And again, I think that a lot of documentary producers, for instance, like to keep it not allow derivative works because there's a story, there's a certain amount of respect with the subjects that they don't feel they have the right to allow the subjects to be mashed up and made into a music video and stuff. But you have to remember that transformation includes things like translation, subtitling, fan subbing and stuff like that. So if you want to post something on .sub, if you use no derivatives, unless you sort of make a special explicit things asking people that they're saying it's okay, you're preventing people from translating it. And if it's a blog post, I find that one of the best things about having a Creative Commons license on a blog post is that you'll get, if it's a popular one, you'll get 8 translations of it very quickly, and it's much more likely to be translated into languages by people who find the article interesting and on the spur of the moment translate it. And I find that if the asking permission part of it inhibits a huge number of people who would otherwise maybe volunteer to translate it or translate it without being asked. So that's kind of that's the trade-off. I guess for lawyers, you probably, you don't want people messing with your
Yeah,
words.
the reason that I use the no derivatives is just because I have to be careful about people turning it into legal advice that it looks like I've given. But I'm more or less worried about that on different days, and that does remind me. You were asking about derivative work examples. I gave you kind of a mushy answer, which reflects the law. But one of the examples of a derivative work under copyright law, at least in the U.S., that is counterintuitive to a lot of people, is a translation. Because a lot of people think of a translation at first as just taking something in one language and just putting it into the other language in sort of a mechanical way. But of course, translation doesn't really work like that because languages don't match up exactly. There's some sort of extra creativity added. So translation is something that falls under derivative work. And one of the ways that some people think about derivative works, although there is debate about this, is that if you've taken enough of the original work and you've added enough to it that you've added something that would by itself be separately copyrightable, if you had the right to hold that, if you weren't the copyright holder, then that would be a derivative work. But again, then we sort of get into metaphysics, and maybe we don't want to get too detailed there, but translations or derivative works. And also back to originality and the low bar for originality. The example I usually give, I don't know why I didn't think to do it then, is photographs. Some photographs, of course, are very posed and the lighting is very carefully done, but even a snapshot is traditionally considered to be copyrightable, even though sometimes it's unclear how much creativity went into it. It's maybe not a whole lot, but it's enough under copyright law. And that can complicate things when it comes to, for example, a photograph of a public domain piece of sculpture. Is that under copyright? Museums sometimes would like to argue that their photograph of a painting that is in a public domain is under copyright, or a photograph of a photograph. And there, you know, I would argue that there's not enough creativity to say there's a copyright in that second photograph. But there's a very but there are cases that would say, you know, that it's a really low level that's required. So
can I ask you a question? 'Cause this,
yeah.
If you're in a museum, are you allowed to take photographs of public domain works?
So question is, if I haven't been repeating the question. So are you getting it? Do you need us to repeat the questions? It's recording? Okay, good. Because a lot of the discussion is really great. So that actually is one of these one of the questions that's best answered again beyond copyright law. So copyright law doesn't really speak to whether you can take a photograph of the painting. The museum's ability to control their property is what speaks to whether you can take a photograph of a painting. Similar with like the bootlegging, the anti-bootlegging statute. You know, there's so many other ways that that there is some control in the hands of the performer. There, the venue has property rights. We all know we get searched before we go into a concert, and often they won't let you take any recording equipment. You may agree via your ticketing, or at least they tell you that you did, you know, that you won't do this. So that's one of those situations where copyright is probably not the most forceful of things in play. Okay, we ready to move to fair use? All right. So the next section of the flow chart, of course, was if it's under copyright, would you be using it under an exception to copyright? And we're mostly going to talk about fair use because for the vast majority of people, that's the most important exception. There are lots of little tiny detailed exceptions or very specific exceptions in copyright law, particularly if you use things for educational purposes in an institution. There are lots of exceptions for you. If you're a librarian or an archivist, there are exceptions for you. But for most people, fair use is the most important exception, and it applies to everybody. So fair use is an area of the law that is I tend to get, of course, an awful lot of questions about it. People are very interested in it, and it's frustrating because of the fact that it isn't the clearest of doctrines. It does not set out these 5 or 6 kinds of things are what you can do. You can't do anything else, and we know what those 5 or 6 things look like. But as I walk through it, I hope that you'll sort of see how it works, and also that the flexibility that's built in by not having 4 or 5 things listed is actually a benefit, even though it makes it's also a negative because it makes it hard for people to rely on it as easily as they would if it were clearer. So the basic text for fair use now is in Section 107 of the Copyright Act. It says right in the statute that notwithstanding 106, which are all those rights, notwithstanding those rights, if you do these certain things in this certain way, then it is not an infringement of copyright. Fair use tends to square copyright along with some other limitations with things like the First Amendment. Whoops, my green thing around market is gone. But anyway, it squares copyright because copyright is regulating the expression of people by saying that the copyright owner gets to control what is done with that work in some pretty important circumstances with things like the First Amendment and the values for free flow of information that we have in the United States in particular. And that's why the United States, or one of the reasons why the United States has pretty much the broadest of these kinds of exceptions in the world. It's much broader than a lot of other countries which have those sort of little lists of things, or even countries that have something that's called fair dealing. So there are in the statute some enumerated favored things that we know are going to be favored if a court looks at your use in order to see whether it's a fair use or whether you're infringing. And the statute says that criticism, comment, news reporting, teaching, scholarship, or research. And then it says, and this is what courts always do, they take the purported fair use and they take the purported copyright infringement and the fair use argument that the alleged infringer has made, and they march through, they look at those favored uses, and then they march through these 4 factors, and they compare the 4 factors in the statute to how the transformative creator who's been accused of copyright infringement is using the work. So what are the 4 factors? The purpose and character of the use. Why were you doing what you were doing? And there are 2 pieces to this analysis that courts make. One is whether it was commercial or non-commercial. So we get back into this question of whether it's commercial or non-commercial. That has that's a little less important usually in the U.S. or in the court's decisions. What's far more important under the first factor, and one of and arguably, I think, in recent case law, the most important factor is the purpose question generally. Why were you doing what you were doing? And did you transform the original work into something in order to meet that good purpose? So criticizing something, commenting on something, transforming it into a parody of itself, those are all highly transformative uses from the perspective of fair use law, and they are very valued by the courts. If it's non-commercial, that weighs in your favor if you're the person who's claiming fair use. If it's commercial, it weighs against your favor, against you. But the courts don't weigh that as heavily as why you were using the work and how you were using the work. The third factor is the amount and substantiality of the portion of the copyrighted work that was taken. So if you had, if you had a movie and you took 3 minutes of the movie, the court would look at that and they would say, okay, it was 3 minutes of a movie that was 2.5 hours long. And the less you use, if you're the person who's claiming fair use, the better for your argument. The more you use, the worse for your argument. However, courts also tend to look at this in light, again, of that really important first factor. And so although it's not any kind of rule beyond a sort of a rule of thumb, the way I like to think about it is, did you use more than you needed in order to meet your good purpose? So did you take more than you needed in order to parody the source material, in order to criticize the source material, in order to do whatever it was you were doing to the source material? Did you take more than you needed, or were you greedy? And then the fourth factor is the second most important factor. In fact, it's been considered the most important factor until fairly recently. It's become more clear that courts are going to read this fourth factor in light of the first factor, and that is, are you having a negative effect on the market or on reasonably foreseeable potential markets for the copyrighted work? So is your claimed fair use substituting for the copyright holder's market? Remember, our whole purpose is to give them some economic rights so they can make some money on this creative work so that they will create it and release it. So this is incredibly important to fair use analysis. There is a little bit of a confusion and could be a gotcha here that we were just talking about in the break, which is, okay, I criticized your work and now nobody will buy your book. So since the fourth factor is so important and the first factor is important, how do those two relate to each other? And fortunately, we've had some guidance from an important court, not the Supreme Court, but an important court recently, and also the Supreme Court in the Two Live Crew case, that basically says, okay, hang on. You have to read the fourth factor in light of the first factor. We are not going to say that if a market gets torpedoed because somebody was critical of the work, that is not a fair use. We're not going to let the market trump fair use in that situation. If we did, we would damage the entire structure that's supposed to be supporting free expression. Because a copyright holder could shut down commentary, could shut down criticism by saying that it hurts our market, right? So long as your purpose is sufficiently tied to commenting on that work, then it looks like courts are going more and more to saying, all right, if that has an ancillary negative effect on the market, that's not the kind of negative effect that we're going to count against you if you're trying to make a fair use. That is the way courts look at it in the most basic nutshell. What's complicated about this and what makes people really frustrated with fair use is that that sounds kind of maybe clear when you hear me say it and you look at the statute, but then you try to apply it to any given situation and it becomes really mushy, just like trying to figure out what commercial or non-commercial is. And it becomes mushier when you understand that, again, we have this quasi-common law sort of system, so that what's important is what situations have actually been in front of courts in the past. What have they actually ruled on? What have they actually gone through the 4 factors looking at and said, this is a fair use? The way that it works in practice is that somebody accuses you of copyright infringement, and then you have the opportunity to say, I'm making a fair use. And maybe it escalates and they sue you. So suddenly you're in court in front of a judge, and you have the right to raise this as a defense. So that it poses a couple of problems. One is, again, Lawrence Lessig, very succinct, says fair use is the right to hire a lawyer as opposed to the right to really use the work in any practical sense. And we're going to get into why that hopefully is changing to some extent and maybe will continue to change over time. And secondly, that in order to really know kind of the parameters of fair use, you have to know a whole bunch of court cases, because the way courts look at any given situation is they look at situations that have come up in the past, and they compare your situation to that situation. That makes it doubly difficult in the new media world because the courts haven't had a lot of cases that look exactly like this. But I'm going to give you a couple of examples of fairly recent cases where the court found that it was a fair use in order to sort of give you a sense of these rules in operation, and because I think these particular cases are really important to the development of the law. The first is the book that I mentioned earlier in the workshop, The Wind Done Gone by Alice Randall, which takes Gone with the Wind and retells it from the perspective of a slave who I believe was Scarlett's half-sister. The Mitchell estate and the publisher of Gone with the Wind sued the publisher of this book. This is another aspect of fair use, is that a lot of the cases that are on the books because we have titans clashing. We have a publisher against a publisher, so it goes all the way to court. People spend the money, and that also weighs against getting good case law that's useful for individual creators, because maybe you can't afford to fight it for that long. So anyway, the Mitchell estate argued this is a derivative work. We have the right. We have the sole exclusive right to create derivative works. Alice Randall and her publisher argued that this was a critical commentary, and it was a parody, in fact, of the original book. Parody in copyright law doesn't necessarily mean that it's funny. It means that you pull up the source material, you copy some of the source material in order to pull it up into the attention of the audience, and then you turn it or twist it or comment on it in some way. Her publisher argued that this is a parody, and they prevailed in the Second Circuit. Just a few years ago, Second Circuit is an important court, and that was a really nice decision that put on record that this kind of transformative parody would be a fair use. The second example is even more recent. This is from, yes, Howard?
That was only good in the Second Circuit, and
yeah.
They settled out of court because they didn't want it to go to the Supreme Court.
Right. So Howard is pointing out, again, another gloss on this that makes, again, it less forceful than maybe we would like in order to understand fair use law and have it have some more clarity, is that this is a case that was, again, as I said, in the Second Circuit, which is the appellate court that includes states including New York, and that means that all the courts under that court are bound by this decision. But the Ninth Circuit, where we live, is not bound by that decision, although they may find it persuasive because it's an important court. And the parties settled at that point because they didn't want to go to the Supreme Court. So when the Supreme Court speaks, then we know what the law is for the whole land. And they didn't want to risk the case in the Supreme Court. We really can only say what this case means in the Second Circuit, although we know it will be persuasive to other circuits, right? The second case I have here is also from the Second Circuit. This is from 2006. This is the Bill Graham Archives sued the publishers of this Grateful Dead illustrated trip coffee table book because the author had used little thumbnail copies of Bill Graham concert posters, if anybody remembers the cool Bill Graham nice art concert posters, in the context of telling the story of the Grateful Dead. This was a question as to whether or not it would be a fair use, because one of the things that was going on in this book was that not every one of those posters was directly being commented on. When you're looking at the first factor and you're looking at the purpose of the work, of the secondary work, the alleged infringer's work, you're looking to see if they are commenting or criticizing or doing something with the original copyrighted material. And some of the Bill Graham posters were sort of in context. In the timeline context, they were used illustratively, but there wasn't any commentary about that specific poster. The Second Circuit said, this is a fair use. And that's a really nice piece of clarity to have on record, again, only in the Second Circuit. The other thing the Second Circuit did in this case was it really clarified that issue between the fourth factor and the first factor, and it said, it coined this term, transformative market, and said in a situation, and here we don't have criticism, right? They were just using some of those posters to illustrate the timeline. Some of them they were commenting on, but they were using it for this illustrative purpose. And Bill Graham said, we could have licensed those. You know, they bought all kinds of images for that book. We sell these images all the time. They're infringing our market. And the court said, no, they were making a transformative fair use. And we're going to say that a transformative market is something that is not covered for the copyright holder. It can't trump the fair use. Again, this is only in the Second Circuit. In the Supreme Court, we have an earlier case, and so the Supreme Court is good for all of America. Two Live Crew case, Campbell versus Acuff Rose, where Two Live Crew parodied Pretty Woman, kind of silly, you know, big hairy woman instead of Pretty Woman. And the Supreme Court in that instance said, you know what, it's a parody, and even though it's commercial, remember that's one of the factors, even though it's commercial, even though they took basically the entire melody of the song, it was transformative, a parody, and therefore we're going to say that it's a fair use. The Bill Graham court sort of took it a little bit further on the market issue and sort of squared that even more with the first factor. Does that all make sense?
If we want to learn more about those cases, where could we, do you have any good references?
Actually, if you email me after, I would be happy to send you the cases and also references. The slides will be up for everybody to take. And I'll also put up I'll put a link to Peter Hurdle's chart and maybe some other sources I'll pull together for people. Yeah. So those were all really important cases that established that so long as you're doing this sort of direct commentary, and in the Bill Graham situation, making this illustrative use, things look pretty good. But these are both books. This is the print world. So what happens when we move to video and we move to quoting from video? Obviously, we can draw clear analogies, right? The fundamental thing that was going on here was commentary on the source. There's no reason why that shouldn't apply, but we don't have as many cases in the video context. The other big issue, big question mark for a lot of DIY media is music, and the reason for that is because the music is often used to comment on the audiovisual source material or to highlight the audiovisual source material. And sometimes the music is used in such a way that there's commentary on the music itself, which, remember, is the safest thing to do. But it's less clear a lot of times. And the other thing is that, you know, for the amount and substantiality, a lot of times the entire or most of the song is used. The second thing about music is this split between the two copyrights, the musical composition and the sound recording, which adds complexity to the situation. Other questions on that? So, given that this is, you know, kind of, I've given you sort of the best cases. I haven't given you the cases that aren't as good, because there are also cases that are maybe not as good for the kinds of transformative use that is at least commenting on the source material that another lawyer would bring up. So what do we do with the situation where we don't have certainty with fair use on either side? Either as the copyright holder who wants to understand whether they're able to shut something down, or the creator who doesn't want to be shut down. And as I said, there's not a perfect answer for this. And if we did decide exactly what fair use looked like, then we'd be stuck with it. And it couldn't grow and expand to engage new media and new uses. Nobody would have, copyright lawyers would not have known whether the the Grateful Dead illustrated trip was a fair use until the court said it. It helps make it flexible, but it does make it frustrating. So there's some efforts, I'm sure about some of them, and Howard already mentioned this one, to try to sort of sort out within communities what they think their best practices are. And this is really important and helpful because courts are interested in that. They're interested in whether a community has a set of norms that actually follow some reasonable path that in that community that people consider fair. And so in the documentary filmmaker world, which for most DIY folks, they're not looking for these formal distribution channels that a lot of documentary filmmakers are looking for, and there are other complexities. But in the documentary filmmaker world, Center for Social Media folks were able to put together a community group from the documentary filmmaker community to talk about what they thought their best practices were with regards to fair use. And they developed this statement, which I had them and I brought them here to LA and then forgot them, unfortunately, but you can get them online, Best Practices in Fair Use, that basically pull apart or sort out several different categories of things that documentary filmmakers think is fairly, reasonably considered fair use. Criticizing and commenting on the source material, using the source material to illustrate something historical or something important. Incidental capture, this is something that has now come up a lot, and we don't have cases to tell us one way or the other, although it seems crazy that it wouldn't be a fair use. We don't know for sure because we don't have a court. When you're filming something, right, let's say, you're video blogging, you're filming something and somebody's cell phone rings with a ringtone. There's some music suddenly in the background. Do you have to license that? That incidental use, that went into the best practices as something that should be a fair use. And then they've split out each one of those into the different steps that you should follow in order to be sure that you're really squaring what you're doing with fair use. So, for example, some of the historical uses to illustrate things, they have more requirements on the filmmaker because those are situations where in some traditional situations you would license the material and pay for it. Anyway, so it's really useful, practically speaking, I think, for documentary filmmakers, but what made it have this incredible force is the fact that some insurance companies have been willing to insure documentary filmmakers' films against infringement claims, saying that they're claiming fair use so long as the lawyer looks at the film and says, yes, I believe that they have followed the best practices. Not the law, which is really hard to pin down, but the best practices. And that has given them a lot of actual weight for documentary filmmakers who, again, they're seeking these other distribution channels, right? But what's important to them is being able to get into that channel. And nobody will put their film on TV, nobody will put their film in the theater until they have insurance. And if they can't get insurance, they can't distribute their film. So it's made a big difference just talking to this community and figuring out their norms and putting them down. The other thing that might be actually useful for folks more directly is the Center for Social Media website has examples, and again, this is documentary film. It's not appropriation or other kinds of participatory media, but they have examples of some shorts that are claiming fair use under the best practices, so you can get an idea of what it looks like in that context. And they have now convened and done a study of remixing reusing, and generally sort of participatory remix culture, where they have talked to people about what they do. They've been working through this again to again try to figure out sort of the kinds of uses that people make outside of the traditional documentary film context and in the DIY media context to try to figure this out. They haven't gotten to best practices at this point, but they have gotten to have publishing a study which you can download up there that kind of talks about what they've mapped. They don't really say, I mean, there aren't best practices, so they don't say this would or would not be a best practice, but they sort of map sort of what people are doing and why they're doing it. And they've come up with these 9 different kinds of ways that people tend to use media in remix, audiovisual remix culture, which have more or less force under analogies to traditional fair use law for fair use. So the first 3, you know, those are the kind of commentary purposes that I've already said tend to be very favored. Quoting to trigger discussion is a really interesting one. I think it's an interesting sort of thing to, it was interesting that they kind of conceptualized this and understood this category, that people sometimes copy stuff and put it up on iMeme or YouTube or whatever without transforming it directly, but they put it up in order to catalyze conversation. So Stephen Colbert's speech at the press club dinner would wasn't ever going to otherwise make it into the rest of the world's understanding because it was a closed environment in which he gave it. So people put it up in order to get people to talk about it. Or people put up Hillary Clinton getting tears in her eyes so people will talk about it. Or people put up John McCain saying bomb, 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 bomb Iran in order for people to talk about it. And even though they haven't actually transformed the material, they put it up. Now, whether that's a fair use, this is a larger question, but we're beginning. The Center for Social Media people are beginning to map them. The only other one that I will mention is archiving vulnerable or revealing materials. So you see how that overlaps with the triggering discussion from the examples I just gave. And pastiche or collage, which is very important to a lot of different remix communities. Putting things together, anime music videos, putting them together, putting a lot of things together into a new work, or vidding, putting things together into a new work. And I'll let you look to see what the Center for Social Media says about those using. Sometimes, again, they're going to fit back into the criticism and commentary. Sometimes it's not going to be so clear. Celebratory videos, for example, highlights videos, maybe not so clear. And I'm hopeful that this project and other projects will help kind of sort out some of that stuff. Now, I don't know that it will, but that's where it is. Any kind of comments or questions on that? Yeah, Steve.
In the hypothetical event that one of the outcomes or one of the legacies of this DIY summit were for us to create a framework or a platform within which members of these specific communities that work in remix practices articulate their own best practices. If we were to try to help to enable them to do that, how specific to individual communities would those best practices need to be? Would we need to have one for AMVs and a different one for vidders, or
so I would welcome other people's thoughts on this, of course. I mean, I think that this is essentially the same question in the copyright context that we were just exploring in the context of privacy and other kinds of issues. Certainly different communities will have different aesthetics and they'll have different traditions and they'll probably have different norms and traditions. How broadly it could be applied, I just don't know. I think it's important to start thinking about it. And I'm really glad that Peter Yazzie and Pat Aufderheide have started kind of working on this sort of more formally, but the more sort of we think about it, I think the better. We all know that there's stuff that isn't as easy to fit under the traditional parameters as we would like. But in the documentary film context, they said, you know what, we think incidental use, even though it's not in the case law, this is a fair use. And everybody kind of knows that it is. Everybody knows that it should be. But we don't have a court that said it. But they're able to move forward. Anyway, so I'm hopeful that continuing this discussion will help, and I agree. Yeah. Wow, this is the only time I've ever not had people ask me questions about fair use. Yeah.
So I really like this point about trying to move away from only transformative use and thinking about moving media into different audiences. You mentioned the McCain, Bob Loren example. I'm wondering, even though this is really attractive, what could it be? What could that not be applied to? Like, would it be too pervasive?
Right. Yeah. So that's. I mean, yeah. So I mean, and again, this is a discussion. This is why it has to be a discussion, and this is why we still, you know, it is hard. It's hard for creators to know what the parameters are, because something like this quoting to trigger discussion. If I am Fox News or CNN, right, I'm going to point out that I need to know what the parameters of that are. Because somebody could just, you know, quote in pieces an entire segment and then claim they wanted to trigger discussion. What's really going to happen in practice, what always has to happen in practice, is that courts look again at individual situations. And so they would look and they would say, did you take more than you needed? Do we believe that this was a purpose, a transformative purpose? Were you harming the market? If you were harming the market, was it because of the purpose that we decided you know, that we are going to allow because we need to allow that? And we get right back into the messiness of it, which I understand, you know, is frustrating. Yeah?
I've had peculiar conversations with people who work in TV news who use the term fair use for just taking 7 seconds or so. In fact, I think that's what they told me was the rule of thumb.
7 seconds was the rule of thumb, yeah.
They say, well, we'll fair use that when they're just taking footage from another channel and didn't ask permission.
Yeah.
I'm curious, first of all, if there's any legal basis for that whatsoever, because I've never heard of it outside that context. And second of all, if that is the standard practice, you know, in TV news, if that's something that people outside the TV news community could point to when borrowing from, in this case it was ABC News, but, you know, Fox, CNN.
Right. And that goes back to Steve's question, which is how specific to a community does this need to be? And the answer is, you know, I'm not really sure. I have heard people use that as a verb. I'll fair use that. And the other thing that, why not? I'll fair use that. But so it's not. It is not true under a full use of the law that any number of seconds is fair use or is not fair use. Any number of lines of a poem or this many paragraphs of a book or this many minutes of a movie is or is not fair use. So they're using a rule of thumb that they think is pretty safe, probably in that context that they're using it in and in the community that they're using it in. You know, I don't know how a court would look at that. I don't know if they're being unduly restrictive on themselves or if they're being maybe a little less restrictive than they should be. But it is important to understand that although people do develop these rules of thumb, that the case law tends to be a lot more flexible than that. And I know, again, we're back into the like flexibility as mushiness, but there's a set of guidelines for educational institutions, I think, that illustrate this point even better because they are restrictive. And I will tell you they're too restrictive. So they say things like, you can use you can quote for an educational purpose, right? This is one of our good purposes, and probably criticism. You can you can use an entire poem so long as it's no more than 250 words. If it's more than 250 words, you can use so many lines, so long as this and that. You can use up to 1,000 cells of a database, so long as this and that. You can use X%, and it's all about how many words. But that isn't how the courts look at it at all. In the Harper and Row case, The Nation magazine used only 300 words out of a 200,000 word book, and the Supreme Court said it wasn't a fair use because what they were doing in the eyes of the court was scooping the publisher of the book, right? So there it wasn't very much, but it wasn't a fair use. In another context, you may be able to use the entire thing because that's what you need to do in order to call it up or to criticize it or to do whatever you're going to do with it, and that was the Two Live Crew case. They used the whole song, basically, the entire melody all the way through, but that was okay because of their purpose. So you can't put these sort of arbitrary amounts on and really reflect the law that well. Yeah, Howard?
Where they do tend to hold a little bit more, though, is when those things were negotiated by groups of both parties. So,
yeah.
You know, in the case of television news borrowing from other television news, if both the takers and the givers are in agreement of a certain amount, then the courts are not likely to challenge
Right.
that in the same way that the
Right, best
the
practices.
educational guidelines
Yeah.
that were mistakenly
Right.
agreed to by some communities.
Right. So you certainly have a floor with those guidelines. And the other thing about the sort of television news example is that, first of all, you know, the courts are going to be interested in the fact that both sides kind of think that this is an okay rule of thumb. And also, practically speaking, and we haven't touched on this, and we really should, practically speaking, if everybody agrees in that community that that's the rule, and here they're all the copyright holders themselves, right? Nobody's going to sue anybody else. So as a matter of practice, it works just fine. Now, for remix folks, you know, usually you're not in the community of the people who produce some of the content that you want to remix.
I maybe should add, the
Yeah.
context was someone giving advice to people on an independent documentary that
Ah.
was going on. And what they
Ah.
assumed the law was based on the
Right.
conversations within their newsroom.
Yeah, so that's a good point. So sort of rule of thumb within the news company, well, and I've seen this happen a lot, people will translate that into a rule and think that it's the law. And that's really understandable because everybody would like some certainty. But that does not get at the breadth or the nuance of what really is in the law.
What about thumbnails? Because the way I typically look at things is if there's somebody bigger than me doing the same thing, then I'm not first in line to get sued. Right? And so I look at Google Images and their thumbnail size, and I figure they're getting away with it. That may be sort of legitimate, fair use-y size for me.
So that actually, so Google's search engine's use of thumbnails, which are of course degraded and thus transformed and taking a little bit less, actually has been through the courts here in our home circuit, the Ninth Circuit. And the first case was the one that I mentioned earlier, Kelly versus Aribasoft, which was an image search engine. Aribasoft is an image search engine that's not Google. And the Ninth Circuit said that those thumbnails were a fair use. Now, that's in the context of indexing in a search engine. So can you translate that into whatever other use you were going to use? You know, that's a little harder to say, but they did say that. And now they're in the process of finishing up the Perfect 10 versus Google case, which that was Google being sued over both the indexing and the thumbnails of those Perfect 10 photos. So, you know, I won't speak to what you should do, but there's what Joey thinks is.
But it is precedent that the court understands that there is such a thing as a thumbnail, and that
yes,
that, I mean,
and
so
that it's transformative,
yeah,
and that it takes less,
right,
because it's diminished. You know, it's so diminished in its resolution that
right.
that
so,
you're taking.
So it's not exactly a rule, but it gives you a position to argue it.
It gives you a great analogy. And that's, I mean, so like the book examples that I gave, those are really useful analogies for the film world and for the DIY world. If you get in front of a court, it's just that you still have to wait for that final decision in order to say, yes, this is a fair use because of the way the law works. Yeah?
Does this work also with the right of publicity that you had mentioned there, like if you want to use a teaser or something?
Right. So right of publicity is completely separate from copyright law. It looks different in different states. In California, it's heavily an economic right, which you might understand. You know, we have Hollywood here. We have a lot of folks whose identities are very valuable commercially. So that's one thread of right of publicity law. Another thread kind of grows out of privacy interests of the person who's being depicted. It varies so much by state that it's hard to say a whole lot of it beyond that. But examples in California of the kinds of things that courts have said are violate the right of publicity would be using a singer's voice. In fact, this was Bette Midler's voice, actually using someone to imitate her voice, sound just like her when she turned down a commercial in order to sell something using her voice. So using the absolute sort of core of it would be using your identity, your voice, or your image in order to sell something in a commercial way. New York is different. New York grows out of common law and has a different set of parameters. One thing that's important about the right of publicity is that it is limited by the First Amendment. So if you have a First Amendment interest that sort of trumps that economic interest, you're going to have a good chance of prevailing. Copyright law, because it regulates expression, like it regulates stuff that the First Amendment speaks to, is kind of weird. It has this sort of unusual relationship with the First Amendment. So we have fair use, we have duration limitations, we don't copyright facts in order to kind of deal with that. When you're dealing with right of publicity or things like trademark law, then the First Amendment kind of acts squarely to make sure that expression is not limited. Now that's really basic, and again, you know, don't just assume that you know what your the parameters of the First Amendment right that you have, but it's the basic kind of framework. Yes.
Would you want to characterize California as a place to exercise special caution in this because of the legacy of, like, the SAG and you know, different pressure groups from Hollywood on the, you know, state law and things like that?
So we haven't, one thing we haven't gotten into, which comes up with some of the source material that a lot of these communities use, are the guilds, you know, and the fact that they also have an interest in some sense because they get residuals, which adds complexity. The question of whether, because we have a lot of very prominent creative industries here who make a lot of money, and we have a lot of celebrities here who have a strong interest around publicity, whether that should make people more cautious, you know, I don't know. We also have some pretty well-developed case law because copyright is so important to the economy that you actually get courts looking at it more often. True in the Second Circuit with New York as well. You know, there are other courts, other areas of the country where they don't see copyright cases often at all. So they don't have the opportunity to develop this sort of nuanced case law. So it's kind of, you know, yes, you know, it may be that you're more likely to be sued, but you're also dealing with people who are pretty sophisticated and know, you know, they rely on the copyright law and they rely on fair use sometimes too. And they understand it in a way that in other places they may not. So it's kind of, you know, it's, I don't know that I would say that one place is better than another to be, unless you're talking about a really specific situation where you know that there's a case in one place that will save you or a case that will sink you. Yeah.
I mean, just to, you know, I'm trying to put this in the perspective of a, you know, experience I recently had making a documentary where we were able to get, you know, 2 major studios to sign off for using clips on fair use, although, you know, in my past life as a student filmmaker, I never would have asked because they
Well, and
would have said no.
And if
but
it's
it was
fair,
like, we'll sign off if they'll sign off.
right. So one
You know,
thing
but
is
if
that,
another studio doesn't sign off, then we won't.
Yeah.
We won't do it.
and you'll often get most favored nation clauses, which say we'll only charge you $200, but if somebody else gets more, we also get more. Yeah. But so one thing that's really important, it goes back to the sort of the set of steps, is that if it's fair use, you don't have to ask permission.
Yeah. Well.
They can't tell you what your fair use rights are. They can only give you a license beyond that. I mean, you know, you can also agree to restrict yourself with contract more than you might under the copyright law. But probably what they were giving you was a license on good terms, right, to give permission to go ahead, and then you don't have to worry about whether you're making a fair use or not.
Right, and it was the conservative nature of the foundation funding
Right.
and the educational institution that made us not be able to do the don't ask.
Right. I want to make one more quick point about permission. You don't need permission for fair use. However, if you ask for permission and it is denied, that won't hurt you in the court. The court, you may, so sometimes, and I completely understand this, that people think, well, if I ask and I get told no, the court is going to look at me askance. Actually, no, it's very well established that it can't hurt you in the court to ask for permission, and it may even help you because it looks like you were acting in good faith. I didn't talk about the final sort of X factor, which is courts will look to see if you were acting in good faith, sort of behaving or bad faith. But, of course, The trade-off is you've exposed yourself to the copyright holder if you ask for permission. So now they know you're there.
So that's it's interesting because the Chicago Manual of Style section on fair use explicitly says not to ask permission.
Not to ask for
because
permission.
it hurts you. So I mean.
That's been. I mean, it's been pretty well established
right.
in the.
So they the way that they argue. Well, they make two arguments. They said
Yeah.
one is don't ask permission because it may hurt you, and I mean, and they may be wrong, but just so that it's interesting that they said that. And then the other thing is that they said that it diminishes fair use in the long run.
Right. So
And-
here's where we get back to the music and the other point I meant to make here. These are mostly just little triggers for myself, and I forgot. And that is, again, the difference between the musical composition and the sound recording, and we get right into this problem. So we've talked about if a community has an established set of best practices of fair use, that might help sort of defend a use like that in the court. There's the opposite issue as well. So in the music world, hip-hop artists used to sample the sound recordings and remix them with abandon. And a lot of times what's being taken, of course, is so small. 3 notes, 4 notes. I mean, there are cases that are 3 notes that you wouldn't even rise to the level of having copied it necessarily if you think about it, right? There's this whole concept in the law of de minimis, meaning you haven't even copied enough to be implicating the copyright. So everybody was doing that, and we got Paul's Boutique, and we got all of these, hip-hop records, and then people got cold feet, there were some threats, and the labels started licensing to each other, always asking permission, always paying something. And now we're in a world where that's the norm. And I really meant to talk about this because so many times people do sample and they use that work. And translating this stuff to music, into the sound recording in particular, is really hard because of this practice of the labels of licensing everything and paying money for everything, so that to a court it can look as though like that there's a market there, right? If there's a market, then we have a fourth factor issue, and that's sort of the norm generally. So there's actually a case from the 11th Circuit, which is a very poorly reasoned case, but it's out there, that says get a license or do not sample. Yochai mentioned the sort of original seminal problematic case that starts out with thou shalt not steal. It's not a very sophisticated level that unfortunately some of the cases on record have been thinking about it, but they've been reflecting this practice of people always asking for permission and always paying. And I think that's what the Chicago Manual of Style is getting at. If you ask for permission all the time, then you have a set of norms and best practices, right, that look like you have to ask permission. And then it looks like maybe that's not fair use, because you don't have to ask permission for fair use. So yes, that's a great point. Yeah.
I guess I had 2 questions. The first was about the incidental recordings, and then if that's been tested, like with the music especially, if there's any.
So the incidental use question is something that has never come up before a court. And so the other thing I want to be sure that folks understand is that sometimes things don't come up before a court because everybody thinks that it's a fair use. And so why would you bother to spend the money to sue somebody if you think that it's a fair use? However, if you're the person who wants to make the use, that doesn't always give you a lot of comfort because it's so expensive to defend against a lawsuit and because the damages in copyright in the U.S. available are really high. But the incidental use, I think, is a good example of that. It's the kind of thing where how could you possibly be harming the market for the work? It seems like the kind of thing that should be a fair use, but we just don't have case law that says so. And there isn't usually comment on it if you're thinking if it's just captured in the background. So having the best practices and having the documentary filmmaker insurers be willing to insure that risk kind of helps people make use of it, even though there's no.
And do they have a standard for what they're willing to insure with incidental, like if there's
So
a
what?
song in the background?
Yes. So what the insurers have been willing to do is to basically go with you use the best practices.
Okay. And the best practices say.
we probably don't have time to go through them in detail, but you can look them. They're on the Center for Social Media website, and it's number 3, which is incidental use, and it describes what the requirements are. You know, not having to be the focus of the show. It really needs to be something that's in the background and just kind of got captured.
But I just want to ask about locations, like location releases.
Yeah. So location releases, that's again getting back outside of copyright and into other limitations and rights, like property rights that people have. Yeah.
The scenario would be say it's an educational nonprofit and it's making documentaries, and you're using, say, footage of people or music or something that's copyrighted, but you're selling your documentaries, but the money's going back into the nonprofit for educational purposes. Is that covered under fair use, or is that? I can go through it again.
I have, you know what, I haven't pulled out, although I've said things are flexible and nuanced and vague, I haven't actually pulled out the lawyer phrase yet, but I have to now, which is it depends. So there's a lot of good stuff going in that scenario. Educational purpose, which we saw in the statute, was good. Nonprofit, that's good. But again, you have to look at it under the circumstances. Yes, Stephen. Then I'm going to try to go through a couple more practical things and talk about the takedown provisions, because yeah.
I was going to invite you to do because it was incredibly useful to me when you said it the other day. I thought I remember you saying at one point in the past that the DMCA didn't have the fair use basically didn't have any place in the DMCA.
Right.
And if so, do people who practically rip media off of DVDs, is there a way to do that through a digital analog,
Yep.
a digital process?
All right, let's do that now. So just finishing up on fair use, more resources. Stanford has Stanford has the documentary film program and the center, the Fair Use Project. So they're actually trying to take good cases to the courts to develop the law, and they're trying to defend people. They can't defend everybody, but they can defend some people. There are also all these clinics, like the one that I run, that will represent artists and help them if they get a cease and desist letter, and in some cases maybe help do some litigation and help sort of with the best practices. So those are all things to think about. There aren't enough pro bono lawyers doing this stuff to cover everybody, but there are more resources than there used to be. And then there's the Organization for Transformative Works, which is pretty new. And this is an organization that, again, is thinking about norms, thinking about what the community remake. This particularly grows out of the Vidding community, what their values are, what they think are best practices, and start, again, trying to sort of pin this down a little bit. Okay, so this is what Steve just mentioned. Section 1201 of the DMCA. Section 1201 of the DMCA says, no person shall circumvent a technological measure that effectively controls access to a work protected under this title, which is a legalistic way of saying protected under copyright. And that's what it says. So if you have a source that is protected by digital rights management, then you run the risk, definitely run the risk of violating the DMCA by going around the DRM, by breaking the encryption, whatever the barrier looks like. And the DMCA, even though it's supposed to be part of the copyright law, it kind of sits out separate and above copyright law in some ways, that it doesn't have an exception for fair use. So even if the use that you're making with the source material that was encrypted is a fair use, there's still the issue of the DMCA violation, the DMCA infringement. So,
is that contested in the courts yet?
It has, and there haven't been a lot of cases. So the Corley case is the most important case. That was the one that was sort of depressing from the perspective of a creator about fair use. There's this other case that kind of is ready to put a little bit of limitation on the DMCA, but there definitely isn't any court that says that fair use limits the DMCA. And it's pretty clearly, people think that this is a real risk. Yeah?
I noticed the word effectively protects. Has that been tested
Yeah,
at all?
it has. So effectively protects. So in order for the DRM to get the backup legal protection of the DMCA, it has to effectively protect access to the work. However, the Corley court tells us that effective doesn't mean a whole lot. It doesn't have, you don't have to prove a whole bunch about how many people it takes to break it. In fact, The DMCA has been termed the Snake Oil Protection Act because it doesn't matter kind of how crappy the DRM is for practical purposes, it's still illegal to break it. The other part of the DMCA that's really important is that it's also illegal to distribute any tools that let you crack the encryption or that lets you get around DRM that protects kind of the way you use stuff within the work. So, so there are those two things that are really problematic. Both there's not the fair use limitation, and tools that let people do this are separately illegal. But this is what Steve was mentioning. There's also the analog hole. So if you just avoid the DRM and the encryption entirely, and capture the analog signal, so rather than using Handbrake, breaking the encryption, but using other programs, which I forgot to like write down some names. I don't remember the top of my head, but about $50, you can just capture the analog output and avoid the DRM entirely and avoid the DMCA for now. Yeah.
Snaps, fraps, and taxi.
What was that?
The
Snaps?
ones that do it off the computer are the ones that capture off the screen that don't break.
Capture off the screen,
Snaps
yeah.
is a Mac only, fraps is a PC one, taxi is a...
Snaps, fraps, and taxi. It sounds like a song, poem. So you know, and Fred said this in the panel on Friday that, you know, when a lawyer says this to people who aren't lawyers, they say, "What? You know, what kind of what? That doesn't make any sense. That doesn't make. There's no real difference there." You know, well, yeah, but that's the way the DMCA works.
And the DMC is, I mean, it's what kind of, I mean, it's a law, but could it be changed?
Yeah, so the DMCA. So going directly to the problem, then yes, yeah. So the DMCA was passed in 1998. We've had it for about 10 years now. It's not very popular in a lot of communities, although it's very popular with Hollywood and the creative industries because they really feel tied to it. They think it gives them the protection they need because DRM always gets broken. So what that means is that, yes, in theory, you could change the law. And in fact, Representative Boucher has introduced a couple of bills that in fact would say, if what you're doing is legal under copyright law, it's not illegal to circumvent the encryption. And so far, it hasn't gone anywhere just because of the political situation. But yes, and Public Knowledge is working on trying again. So yeah, Howard.
One more thing. There is an exception to the anti-circumvention provisions for those of us who are teachers.
Yes.
In a face-to-face teaching situation at an educational institution.
Right.
And so we can legally break the encryption, though no one can legally sell us the software. Can market the software for us to use, but we can legally break the encryption to use it.
We can also show movies in class if it's a face-to-face teaching situation. There's a special Section 110 exemption that lets us do that. So for those of you who aren't the creators but the teachers, that's a really powerful exception for teachers in the law. But so the DMCA is a great example of having a few little limitations that are exceptions and no general rule. That may be frustrating and it may be vague because it's flexible, but it's flexible.
But what if you're not the one that did like what if I download a ripped copy?
Right, yeah, so the liability rests with the person who ripped it or the person who distributes the tool.
What if the person is a teacher?
Like, I am constantly getting questions from my colleagues. They want me to send them the software to rip these things. And I can't do that legally.
But you could, but what if you rip it?
So
I can become a service. You want me to become a service for them? That would be a full-time job.
So the exceptions are really, so the purpose, so the way I understand it, the exceptions are really limited, and so it's tied so much to the purpose. So if you're beyond the purpose that's set forth in the exception, then you don't fall into the exception. Whether that would go back,
I'm just trying to figure out who would be liable if I did an MV video based on stuff that from this conference,
Right.
say, and then
Right.
I got sued under the DMCA,
right.
I would say, well, I didn't
Right.
do anything.
So this is why the DMCA, okay, and here I've editorialized a little bit throughout the talk. I'm really going to editorialize now. This is why the DMCA is useless in any practical sense to the people who would like it to be useful, right? Because all encryption gets cracked, and it usually gets cracked right away, and all the bits are out to be copied freely. And you know, Joey, if you pull the material down and it's already decrypted, you didn't decrypt it.
Right.
You're not liable under the DMCA. You're just liable whatever copyright infringement you may make, right? So, you know, to try to stop, you know, and there are real pirates out there. You know, there are people who are commercial pirates who do not care, you know, that there are some extra remedies in this law, thousands of dollars of remedies, and for criminal levels of things, $1 million, right? They don't care, they're criminals. They'll always break it, and it'll always be out there for people to use. So that's why the law itself is, I think, poor thinking. But as to the question of liability, right, it goes to the person who actually breaks it. And then once it's out there, it's a question of general copyright infringement.
So it's Howard's responsibility not to allow students to make copies of the stuff that he uses, that he rips. Otherwise, he could be like, I mean, this is getting theoretical.
Yeah, so the Teach Act, I mean, we should talk about the exceptions a little bit. So there's the 110, which lets you actually teach in person. But then, of course, we don't all teach in person anymore. I teach a class in the engineering school, which is a distance class, and I have some people in the room and some people elsewhere. And then there's the Teach Act, which is supposed to let you do this kind of distance learning, but it's so, again, it's so limited, and it's so tied to a particular technology at a particular time that it's essentially useless. And that's what happens with a lot of these exemptions.
Yeah. I'm in that situation because I'm teaching online and I'm trying to teach media production and media
Right.
analysis.
How do you do that?
I've been,
Yeah.
doing stuff, but often using YouTube.
Yeah. So are you here?
I'm at Florida State.
Okay, so I'll ask. I did a presentation here about academic fair use and some of that stuff, which I would be delighted to share so long as everybody is. Yeah. Okay. All right. So more on the DMCA, or this is my little map. This is copyright. This is all the possible things you could do with a copyrighted work. This is copyright law. So the copyright holder gets to control this subset of uses. But for example, if you have a book, you can read a chapter 5 times, and you can skip the next one. You can stomp on the book. You can rip it in half. That's just not part of what the copyright holder gets to do. Then there are the exceptions. And then there's first sale, which says that I own the copy of the book. I can sell it. You move on to the DMCA, and you have this first diagram that shows the darker blue being what the copyright holder can control, and the rest of it being how the information is moving through the culture. And then you have DRM, which provides or could provide exclusive control, because through the computer code you decide what people can do with the work, and then you permit them. So it completely turns the whole model inside out. Anyway, that's just my editorializing. We can move on beyond that. The last topic, and you can decide, how much you want to go into this. I'll be very brief, and then we can decide if there's any detail. Is the issue of all of the intermediaries that are used to distribute this content. And Jonathan, I took this from your blog, so I hope this is okay. Okay. So all these different intermediaries, lots and lots of them. Here's a video, right? It's a great critical video. I clicked on it, I wanted to watch it, it's no longer available. Why is it no longer available? Almost certainly because YouTube got a notice under the notice and takedown provisions of the other part of the DMCA, Section 512. And they took the material down. So why did they do that? They did that because Section 512, actually, it has both positives and negatives. So Section 512 says if you're the intermediary, if you're Google as a search engine, if you're the host, or if you're providing connectivity, then we're not going to say that you're liable for your user's infringement, which in the offline world they would be. It doesn't matter who wrote the infringing book in the bookstore owner is liable. You're not going to be liable for all the stuff that's on your platform or traveling over your network. but you have to follow some rules, and you have to follow different rules depending on who you are. So for YouTube, which is a hosting provider, they have to follow Section 512C, which looks something like this. There's a copyrighted work. My example is a Chick tract. Jack Chick writes these evangelical Christian cartoons, and somebody makes a parody of that track. This is an actual parody using H.P. Lovecraft. So we got H.P. Lovecraft going on here now as another copyright issue, but H.P. Lovecraft and the elder gods coming after you instead of sinners going to hell, which is what happens in the choice. So the copyright holder for the first work sends to the OSP, the online service provider. Let's say that we're talking about YouTube, although this is not audiovisual, but the host, a takedown notice saying, this person's infringing my copyright. The OSP takes it down. Then they notify the person whose work has been complained of and says, this person says that you're infringing their copyright. So for many people, what happens is you just have the shot that I just showed you, where the video disappears. And everyone's like, oh, it disappears. It didn't last on YouTube. And maybe somebody puts it back up and sort of resees it, but it didn't last. But in fact, you can send a counter notice back to the online service provider and say, you know what, and it does have to be under penalty of perjury. I am sure that this is not infringing, so I'm really quite sure that this is not infringing. And then what we do, the OSP forwards that to the copyright holder, who knows then that you're saying, no, guess what, I'm not infringing. And then everybody waits for 10 to 14 days. Well, notice the material is usually still down, although it's not necessarily required. That's in practice what usually happens. Everybody waits for 10 to 14 days. If the copyright holder doesn't file a lawsuit in that time, then the service provider can put it back up, and they'll still have their protection against secondary liability. They'll still have a safe harbor. So the good thing about this, for creativity and sort of for remix media, is that it doesn't act at the beginning, right? And if the person doesn't sue, then it goes back up. So the idea behind it, or the argument behind it, was that otherwise online service providers will feel like they have to censor everything because they're going to be so worried about infringement. Now, whether that would have happened, we don't know, because the law was passed before it fully developed, that situation fully developed, or whether case law fully developed. But that was the idea. Now, of course, the problem with it is that we're not looking at a judge here looking at things and deciding whether this is a fair use. We're not arguing over this at any sort of great level of detail, unless YouTube, if it's YouTube, if the folks inside YouTube, have a bunch of people looking at it and debating about it. The great incentive is to just pull it down. And that's sort of the challenge for it. And for that, we have 512F, which says if knowingly somebody sends a notice when something isn't actually copyright infringement, then you can sue the service provider, and you can sue the copyright holder in order to get it put back up and get damages. However, knowing, I mean, we've just spent 2.5 hours talking about knowing whether something's infringing. It's really hard to meet that standard. So 512F hasn't been used as much until recently, when people like the EFF and the Fair Use Project and some other folks have actually started trying to use it to get stuff put back up. So there are sort of 2 points I want to make about this that I haven't. One is that this can be that this does allow YouTube to go ahead and pull stuff down instead of filter it from the very beginning, although yes, they are beginning to sort of filter things. But the law at least gives them the ability to decide to take stuff down after it's already up. And that's certainly better than keeping it up to begin with. Now, they've been sued by Viacom for $1 billion to decide whether they can actually take advantage of the safe harbor, and they're also being pressured to filter, and they're working on that. But that's the one point I want to make about it. The second is that if you yourself are a hosting provider, like I said, you have a blog with a comment function and people put stuff in it, you could take advantage of the safe harbor provisions yourself so that you don't have to worry about what other people post. It's not that straightforward. I mean, it's pretty straightforward, but you do have to take some steps. You have to follow the steps required in the statute, designate somebody to accept notices of takedown for you. You have to have a policy in place of how you're going to deal with copyright infringement, and that policy has to require that you will terminate repeat infringers. So that's the other thing about 512 that can have a negative effect. Jonathan asked me about this the day before yesterday, I think, that, well, what if you just keep putting it back up and it keeps coming down? Then you're in the world of trying to figure out what the OSP has decided repeat infringer means, right? And would they just terminate you entirely?
What if it's your own content? What if you put something on your own site as a blogger?
Right.
And you get it. I mean, you can still take it down.
So if it's your own content and it's not somebody posting, then you don't get that. The safe harbor is only for secondary liability, which means other people's infringement.
Right.
But you being held liable for other people's infringement. So if you put it up yourself, then you don't get the safe harbor. If you get a cease and desist letter, you can decide to take it down,
Right.
but you can't claim the safe harbor.
But I guess my question is, so maybe it's not DMCA, but if you put up something that's questionable,
right,
and if you take it down when you get a takedown notice,
right,
you're not really at risk as much as, say, if it were a, I mean, what is it? Are
right.
you at risk? I guess is the question.
So if you're the person who actually puts something up and you get a cease and desist letter and you take it down, that doesn't inoculate you against them suing you. Right. What it does is it limits whatever damages were in place up to the point at which it was taken down.
But you're not as safe as a service provider.
You're not. There's no rule that that they could still go ahead and sue you, right? And because of statutory damages in copyright law in the U.S., which means that they can elect thousands of dollars, or they can elect. I mean, it's a sliding scale, but they can elect not to even have to show exactly how much you damage them. There's still the risk for the liability from the beginning before you took it down.
But it is damages then that they sue you for. I mean,
right.
So you have to have damage then.
Right. And in most circumstances, that's what it's going to be. Because what injunction just meaning the court actually telling you to do something as opposed to telling you to pay. What would they ask you to do besides take it down? Probably nothing else. They might ask you to destroy any copies that you had. Mm-hmm. So there are some other things that they might want you to do. But for the most part, they're probably going to want it to be taken down. Yes, Jonathan?
Just real quick, that in your graph there, you had a thing where they told you they took it down, right? And you get to say, oh, no.
Yeah.
That doesn't actually happen.
Right. So this is a gloss that I would have, if we had more time, I would have gone more into. So depending on what kind of service provider you are, you don't always even have the kind of service relationship with people to send them a notice, and it's not required. So for search engines, they're actually not required to send the counter notice back, or to let the alleged infringer know before they take material out of the index, which kind of has to make sense because they don't have a service relationship with that person.
So on YouTube, I only needed things taken down when users who were trying to see it emailed me and said, oh, I can't see it anymore. And then I went to look and it was gone.
Right.
Is stuff on your account or?
So that's a question of how they're interpreting the requirements under 512. So I'm not really sure how they're looking at it. So this is the Copyright Office page that tells you how to sign up for 512 if you do have people post and you'd like to. And I know I went over this really quickly. chillingeffects.org has information in FAQ form about a lot of this stuff. This is their one on the safe harbor provisions that I've just been talking about. They also have a counter notice generator where you check all the boxes required from the statute and you fill in the information and you hit execute and it creates a render and it renders a PDF letter that's already done for you to sign and send back. I did want to point out a couple of things. First of all, you have to consent to the jurisdiction of the court where you live, meaning that they could hear this case over you if it got that far. You consent to service, meaning that you already have agreed that you will accept the demands from the court that you appear. It also says I live in the United States. And that's because you have to accept the jurisdiction of the federal courts, and you have to put your name. So I point all of those things out because for some anonymous users, this may be something that is hard for them to do. And the second thing is that you do have to have a belief that it's not infringing. It should be backed up by something, and you sign that under penalty of perjury. Okay. That's it. We didn't get, and I know we didn't get to trademark and stuff. I mean, we can definitely talk more offline if you'd like, and here are some more sort of context for the clinics that I'm involved in, and basic more information about some of the stuff I talked about.
You said we'll be able to download that?
Yes, I just have to find out where it's going to be posted.
We'll follow up. It'll give us a couple weeks to get all the video and stuff, but it will be up there, whoever's in wish. Well.
I guess this is the end of the conference.